Yes, roll number 10.
Yes, sir.
Sir, read the biodata, sir. Answer.
Yes, sir. सर रीड करना है?
Yes, sir.
Shall I start now?
Sir, you can proceed.
Yes, sir. Thank you, sir. Thank you. Good afternoon, everyone, and welcome all the participants for the afternoon session of 16th FIP. Myself, Professor Shivaji Suryavanshi, Principal of the People's Education Societies, College of Physical Education, Chhatrapati Sambhaji Nagar, Aurangabad. On behalf of the UGC MMTC of Dr. Babasaheb Ambedkar Marathwada University, today I am here to read the biodata of today's afternoon session resource person for online 16th faculty induction program. Today we have the eminent speaker and resource person from chemical technology domain, Dr. Sachin Bhusare sir. He is the assistant professor and head of the department of DMPK studies, that is for drug metabolism and pharmacokinetics at Dr. Babasaheb Ambedkar Marathwada University, Chhatrapati Sambhaji Nagar. Dr. Sachin Bhusare sir has completed M Pharma and PhD from BITS Pilani with PDCR clinical research. Sachin Bhusare sir holding assistant professor at University Department of Chemical Technology, that is UDCT of Dr. Babasaheb Ambedkar Marathwada University from September 2009 to till date. He is working as a head Center for Drug Metabolism and Pharmacokinetics at UDCT of Dr. Babasaheb Ambedkar Marathwada University, Chhatrapati Sambhaji Nagar. His research area of experience is preclinical drug development from ancient system of medicines, analytical and bioanalytical method development, pharmacokinetic studies, formulation and biochemical assay development. Having 3 Indian patents registered and granted on his name, his 85 international and national research papers has been published by him. 1 book chapter is also published. Dr. Bhusare sir is also engaged in contract research projects and consultancies. He is engaged in 5 industrial research projects, that is of Alchem, Flavosis, Virbac, Savera, Inchem, and 2 government research projects of FDA Forensic Science Department of Chhatrapati Sambhaji Nagar. Dr. Bhusare sir is also having 23-year academic research grants on his name. Some of specific is DST DRP project, which is of 3.68 crores in 2019 to 2022. CSIR 20 lakh for 2019 to 2022 year. DBT research projects of 19.13 lakh in year 2014 to 17. UGC major research project of 11.74 lakhs in year 2013 to 16. DST project 24 lakh in the year 2012 to 15. Dr. Sachin Bhusare sir has got professional recognition, awards and fellowships such as recipient of National Facility of Bioanalysis, recipient of DST Fast Track Scheme for Young Scientists, recipient of Senior Research Fellowship of CSIR Government of India, gold medalist and stood first in the merit list of B Pharma, best ongoing students and stood first in the merit list of D Pharma. Dr. Sachin Bhusare sir has worked on different professional positions such as member of the Innovation Incubation Linkage of Dr. BAMU, member of Research and Recognition Committee of BAMU, chairman of Ad hoc Board Herbal Technology of Dr. BAMU, member of Ad hoc Board Department of Chemical Technology, member of Ad hoc Board Pharmacy, member of Departmental Research Committee, member of Research Advisory Committee, member of Research Advisory Committee from Ved Prakash Patil Pharmacy College. All the educational eminent personality we are having today for our afternoon session. I specifically express my gratitude for his presence and warm welcome by inviting him to express his views and presentation for today's afternoon session of the online 16th faculty induction program. I hope all the participants, faculty members of 16th FIP will be enlightened by the lecture of Dr. Bhusari sir. Lastly, I express my deep gratitude towards the Director of HRDC MMTC of our university, course coordinator, and Dr. Rafe sir for giving an opportunity to read the biodata of today's resource person of Dr. Bhusari sir. At last, thank you. Thank you, sir.
Thank you very much. Thank you very much for this nice introduction, sir. Thank you very much. So first of all, I would like to thank Director of MMTTC and Assistant Director for giving me the opportunity to share my views with you people. So for next 3 hours, I will be with you, and for these 3 hours, we'll be having two different sessions. In first session, first lecture will be based on Indian patent system, and second is based on human health. Second is a very generic lecture, which will be again very useful for all of you. And this is also a first lecture which is applicable for almost everybody, because we are into this knowledge system now. Our world is full of knowledge, and now if you create anything by your mind, by your knowledge, if you create something, that right should be with you. So my intention to tell you about Indian patent system is, the person who may belong to any stream of the science and technology, as well as languages, as well as interdisciplinary, one should know about the patenting, one should know about the intellectual properties. So that way, if you learn this nicely, if you practice it, then it will be an asset for you. There is no binding of what you can say qualification. So qualification does not make much difference if you understand this very well. So let us start today's session. It's a Indian patent system theory to practice. For this session, I planned it in such a way that some of the theory part I will cover, and I will let you know how to practice it, how to file it, filing procedures, what are the filing procedures, and how, because this is all commercial affair. So everybody actually do not share these things to anybody. But for me, as I am a teacher and all of you are teacher, so we should know each other very well, and we should share, so that anybody from your group, if he or she is interested, and if he or she practices it, then it's worth. So delivery of this lecture will be worth. So let us start for today's first session, that is Indian patent system theory to practice. So now, for scope of the presentation for today's session, my topic will be covering intellectual property rights. So introduction about the IPR types, as well as the main focus will be on the patents, because IPR, there are different varieties of the IPR. So we'll more interested to know about patent, because patent is quite a fascinating word for everybody. Everybody actually look towards the patent in such mesmerable ways. So what it is basically, in general, everybody wants to know, curiosity is there. So this is one of the reasons which for because of which I selected this topic. And under patent, I'll be sharing with you the criteria of patentability. What are the criteria, as whether you can apply some test, and if you know, because lot many times there are questions like, sir, my idea whether it is patentable or not, am I going to get it? Yes, you can do it by yourself. So for today's in today's session, I will explain that also. Then various types of the patents, then types of the patent applications, then requirements for filing patents, patent filing procedures, and patent database. Okay, so now intellectual property rights. Let us start with this intellectual property rights. IPR is a short form, basically intellectual property rights, IPR. So now what it is basically, so just go through that, the bold words: creation of mind, anything that you create by your mind, thought process. Okay, so that comes under actually this IPR. So what are the creations of the minds? What kind of things we generate from the mind? Inventions, literary and artistic work, design, symbols, names, and images in the commerce. The last two words are very important. In commerce, whatever you create by your brain, if you are going to use that in business now, so then that comes under IPR, because you have to protect your right. Say suppose you are good at art and you draw some picture, good picture. So rationality is anybody who do it, he or she will want that my name should be there on the picture, correct? So what is that? This is one type of way of conveying the people that yes, this property belongs to me. And if you do it legally, then it comes under intellectual property rights. So it's a creation of mind. So creation of minds can be, which I explained, like inventions, literary, artistic work and all. Now IP, intellectual property. Basically, there are some parameters or there are some characteristics of this IP. So straight away, it is something like the property which is created by the application of the mind. You apply your brain, you apply your thought, and you generate something. And if you convert it into some technical part, then it becomes a property. So what are the typical characteristics of this intellectual property? First property is this, this characteristic is, this is intangible in nature. That means you cannot see it. Basically it is a non-physical intellectual property, because whatever idea is in your brain, whatever you think, whatever you create, it is in brain na, right now, first of all. So it is something like intangible, non-physical form. Second is, it is a key to techno-economic growth, because the classical examples are there. Samsung, Apple, they earn through patents, they own so many patents. So by using this patent technology, by using this IP, actually you can progress in both ways, technologically as well as economically. So it's a key. And second is, third is territorial in nature. Intellectual property is territorial in nature. The clear-cut meaning of this is, if you are in India, if you think something and you got some idea, if you register that idea, then this will be applicable in India because you applied in Indian Patent Office, correct? If you apply in abroad, then it will be applicable there also. So there are three characteristics. One is intangible in nature, second is key to techno-economic growth, and third is territorial in nature, correct? Now, what are the property rights? Basically, property rights, how you earn the property rights. Because when it comes to rights, that means you own it, correct? So intellectual property rights, actually you can own it, you can earn it through patents, copyrights, and trademarks. These are the three classical ways by which you can actually earn the rights: patents, copyrights, and trademarks. Now, few slides onwards, you will come to know between the differences between this patent, copyright, and trademarks. Okay, and one more characteristic which is there for IP, intellectual properties, it gives you the monopoly for the specified or specific time period. That means if you patent some idea, so for some period like 20 years, you will be solely the person who can practice that patent. Nobody in the world can practice this in India itself. Okay, if you belong to India and if your application is Indian Patent Office, application is for Indian Patent Office. So it is a monopoly. That means you are the sole authority who can practice your invention. That's a monopoly, correct? So it is a creation of mind. There are three characteristics, and property rights can be earned through patent, copyright, and trademark, and it is a monopoly for specific time period. Now, the next question comes in mind immediately. Sir, you told us about the intellectual property creation of mind. Why do I need it? What is the need of the IPR? Why to secure the rights? Okay, you create anything, but why to secure the rights? It is something like, if you have this any poem which you created, obviously you want that that poem should be on your name, correct? So this is one of the classical ways to identify the needs of the IPR. Why you want IPR? So IPR, if you secure any right, then it safeguards the rights of the creator. That means it is on your name only. Okay, so tomorrow it may happen that you created something and somebody else is claiming, no, it is not Sachin Bhusare's property, it is my property. How come it should be? Rather, it is technically wrong. So if you want to safeguard your rights, then IPR is the right way. So how to do it or why to do it? Then next slides again I'm going to discuss. So the first need of the IPR is, if you want to protect your rights, then IPR is needed. Second, it ensures the ease of doing the business. Why? Because any idea, if it is with you, you can share that idea only when if you have a legal documents with you for this idea, that this idea belongs to you. So doing the business becomes very easy if you secure the IPR. So second part, why to go for IPR is for the business purpose. Third, it actually triggers the economic growth. That is the classical part of IPR. Just by creating the properties by your mind, you can earn like anything. Economic growth. Okay. So third is economic growth. Then fourth requirement, or what you can say is need, is it facilitates the transfer of technology. If you are having an IPR with you, you can shift that IPR from your side to another side or another company or any other person. And in exchange of that, you can earn the money. So transfer of technology is quite possible. Okay. And next is the encouragement in the innovation. Whenever you innovate something, and if you are getting the money in return of that, definitely it is going to encourage your innovation. So IPR is needed for this. So there are 5 classical parts why you need IPR: safeguarding the rights, doing the business, economic growth, technology transfer easiness, and then innovation triggering. Correct? Now, this slide is very important as far as lecture is concerned, because last 2-3 slides we are talking about the IPR. Now, the main question comes in mind, sir, what is IPR? That is first part. And what are the different types of the IPR? So first, we understood very well IPR. IPR means it's a right created by your ideas. So it's a brain. By your brain, you generate something, and if you secure the rights, then it becomes IPR, intellectual property rights. So now, what are the different formats? The first classical format of IPR is patents. Okay, the first one, patent. Second is trademark. Third is copyright. Fourth is trade secret. Fifth is geographical indication. And sixth is industrial designs. So there is a huge difference between all these various types of the intellectual property rights. We are more aware of, little bit aware of patents and copyrights, but for trademarks, we may not, because we all belong to service class, and somebody of you may have this inclination towards the business. So those who are into business, they know the importance of the trademark. Rest, trade secrets, geographical indications, and industrial designs. These are the types of the intellectual properties where we do not have that inclination or understanding. But yes, for today's session, I'm going to explain that also. So what are the types of the intellectual property rights? Patents, trademarks, copyrights, trade secrets, geographical indications, and industrial designs. These are the classical 6 different forms of IPR with which we used to deal. Okay. Now, the most important, once again, so what is protected under what? Because lot many times there are questions in my lectures, sir, what is the meaning of patent? What is the meaning of copyright? What is the meaning of trade secret, the trademarks? So this slide explains it very well. Patents. So if you have an innovative product, process, or new application, all these 3 criteria. If you have a product or a new process or new application, so if you want to secure a right, then you have to go for patenting. You can go for patenting, IPR filing. The one format of IPR is patent. So for product, process, and new applications, you have to go for patenting. Now, if you want to actually reserve a right for the outer shapes, contour or configuration, shape, size, then it is not patent, it is design. So sometimes it is a design patent also, but people used to call it as a design. It comes under design. So you have to secure a right under design. Now, if you are doing business with some name, typical name, brand name, you are calling it as a brand name for your own business, or logos. Okay. So if you want that this logo or brand name should not be used by any other person, so what is to be done? Parleji, this is the brand name which is already registered. We cannot use it. Parleji. Can you? You cannot use it. Okay. So these are all brand names, logos. Even Tata, Hyundai, even you can take the example of any other car. So logos. This logo is typically of companies. So that is a registered trademark, registered logo or registered brand name, and that comes under trademark. If you want to secure a right, then you have to apply under trademark. Now, if you have client list formula for a product like Coca-Cola, so that is trade secret. No one actually reserves a right. They keep it as a secret. That comes under trade secret. So there are fascinating actually rumors also. So there are so many products which for which you do not know the formula. Coca-Cola is the classical example where till today everyone is claiming that no one knows the formula of the Coca-Cola, and that is true. Partly it is true also. You cannot mimic it because they kept that secret so nicely, but generally that is not registered under trade secret. Okay, trade secret is one separate area where you can secure your uh, product composition or client list. And if you create something like music, art, play, poems, so that cannot be patented. That comes under copyright. Copyright. So this is the classical difference between patent and copyright. So for copyright, if you want to register, then you must have something like new music, new artwork, play, or poems, and that is denoted as a C in the circle. For trademark, it is R in the circle, registered trademark. Okay, so now clear what is patent, what is copyright. Okay, now
Yes, sir.
slides, is it visible? Is it visible? दिसतंय का?
Yes, sir.
Okay, no
Yes,
problem.
sir.
Yes, yes. Because so many times there may be some technical error. Just let me know. जर तसं काही वाटलं तर सांगा. ऐसा कुछ होता है तो बताना. ठीक है? Okay.
Okay,
So
sir.
now what is protected under what? Because so many times people used to ask, sir, कौन सा कहाँ पे register करना है? So last slide explains it very well. This is the pictorial representation of the same slide where you can easily find out what is registered under what, how to protect your right. So if you, it is a Tirupati laddu, okay, left, lower bottom, left side. So geographical indication. Now I would like to talk about geographical indication by using two examples: extreme left down and extreme right down, Kolhapuri chappal and Tirupati laddu. See, Kolhapur people, actually that region has registered this Kolhapuri chappal as a geographical indication in that region. And same happened in Tirupati also. Tirupati laddu is geographical indication. It is registered under geographical indications. Now, it clearly means that the laddu, the quality of that laddu or quality of the chappal, if you take it from that particular region, like Tirupati or like Kolhapur, so it will be a specified quality of the product, then only you can say yes, it is Tirupati laddu and it is Kolhapuri chappal. So it's geographical indication means it is clear that that product belongs to that particular region, geographical zone. Okay, now it is not so simple. You cannot claim that Anjir is belonging to Aurangabad or Chhatrapati Sambhajinagar. Okay, for that you have to register that product under geographical indication, and you have to prove this variety is having specific qualities which you cannot obtain from any other side. Just like Alfonso, just like Alfonso, Hapus. So they have got Alfonso, registered one. So same taste, same line, texture of the pulp you cannot expect from the other zones. So geographical indication means that product belongs to that native place and which bears specific quality that cannot be obtained if you take the product from other regions. So that is called geographical indications. So there are so many geographical indications which are registered in our Indian Patent Office. So you can go through Indian Patent Office site and you can get it. Now I would like to talk about trademark. So Apple, the right side top trademark. So this is a typical logo of Apple that cannot be used by anybody else in the business. So that is registered one. And if you mimic it, if you try to use it, you have to pay a heavy penalty that you cannot imagine. There was a famous legal case between Samsung and Apple. You might be knowing, everybody might be knowing. Samsung has to pay a huge amount because they actually cracked the patents and they use some data, design data of Apple. And Apple proved that Samsung has made that mistake and they have to pay huge penalty. That was in international court. Okay, so you even cannot mimic the trademark, even outer design also. Just like fan example is there. So left side top industrial design. This is the classical design of a typical fan. You cannot mimic it. If you register it under industrial design, then nobody in the market can mimic it. Nobody in the market can mimic it. One more classical example, Coca-Cola. So here in center point, here in this same bottle, you can find number of intellectual properties in the same set. Like the formula is trade secret. No one knows, correct? Now the way the Coca-Cola has written, Coca-Cola, correct? So that is a trademark. Nobody can mimic that. It is a registered one. Now there is a typical size shape of the bottle, and that is again registered, so it comes under industrial design. Okay, and there is one more patent which is involved there. So now you can find out the difference between the patent, trade secret, trademark, industrial design. Okay, geographical indications. So clear? Yes. So now next part of this is, when we talk about intellectual property, then intellectual property rights, what are the types, what are the different ways by which you can secure the rights. Now again question comes in mind, sir, is it for lifetime? If I do something, if I create something by my brain, is it my property throughout my life? No, it is not like that. So there are specific domains where you can get a lifelong protection, but not in all cases. So this slide explains it very nicely. So those who are into patent filing, or those who are planning to file a patent, okay, so for them the information is very good. You have maximum protection of 20 years. That means the date on which you submit the patent in the patent office, the initial date of registration, your protection period starts from that date. Okay, so 20 years is the maximum protection period for the patent. That means it is very clearly evident that those who are into patent filing will have a total period of practicing that patent is 20 years. After 20 years, this patent will become a public property. Then anybody can use it. Those who are into pharma, food, they know it very well. After patent expiry, everybody can practice that patent. And that is more crucial in the pharmaceuticals. I belong to pharmaceuticals, so that's why I'm sharing this. Now, but for this, the renewal, every year you have to renew it. Every year you have to renew it. If you by chance miss that renewal, so there is specific period 6 months before which you have to renew it by paying additional fees. Next to that, subsequent 2 times, then your patent will be null and void. It will not exist as a patent on your own name. Then it will be typically a public property. Anybody can use it. So what are the acts and rule by which it is abide? The Patent Act 1970, which is amended in 2005. Now trademark, if you are dealing with trademark, it is lifelong. So that's why Tata and all the automotive companies, even Apple, the registered trademark, it is lifetime protection. But the baseline is every 10 years you have to renew it by paying some amount. And it comes under Trademark Act 1999, which was amended in 2010. For design maximum protection is 15 years. And after 10 years, for next 5 years, you have to renew it. Okay. Then it comes under Design Act 2000. There is mistake on the slide, 2000. It should be 2000, not 200. Huh? My mistake, sorry. It's a 2000 design rules 2014. Now for copyright, again it is 60 years. That means almost lifetime. Okay, copyright is maximum protection 60 years. So that's why if you write some books, novels, articles, so it becomes your property for next 60 years. But for that, you have to register that under copyright. Huh? Just by merely writing the book, you may not get the copyright. Okay, you have to apply it. You have to apply for the copyright. Otherwise, so many times people used to ask, sir, I wrote one book, and is it my copyright? No, no, no. You have to register it. Okay? Renewal is not required. It comes under Copyright Act 1957, which was amended in 2012. And GI indication, again, it is a lifetime protection. After 10 years, you have to renew it. So geographical indication of goods, that comes under this Act 1999. Now, listen carefully. The last bottom line, just focus on that. Patent will cease and be transferred to public domain if patents are not renewed within 6 months of expiry of concerned year by paying renewal fee. That is more important. Okay, so don't miss to renew your patent. Every year it is mandatory. I do have 3 4 patents with me, so I know every year it is time bound program. So I wrote it on my board. So every year I have to submit that amount. So be specific. Those who are into patent filing or those who are planning for patenting, just keep this thing in mind. Now, what is the organizational structure? Now, because just mere understanding of IPR will not help you. You must know what are the setups in which I have to apply. So that is called organizational structure. So actually all this IPR comes under domain of Ministry of Commerce and Industry Department of Industrial Policy and Promotion. And there is one typical authority which is designated by this Industrial Policy and Promotion Ministry, that is called Controller General of Patents, Designs and Trademarks. Controller General of Patent, Design and Trademark. Similar authority is there in pharma also, Controller General of Drugs of India. Huh? So on same line, you will have authority of Controller General in Patent, Design and Trademark. Under this, there are 4 domains. One is Patent and Design Office domain, where you can find that there are 4 classical offices of the patents. One is Kolkata, another is Delhi, third is Mumbai, and fourth is Chennai. So it covers entire India: Kolkata, Delhi, Mumbai, Chennai. Now, trademark registry, apart from these 4, there is one more additional office for the trademark registration, that is called Ahmedabad, that is in Ahmedabad. So that is one more addition for the trademark registry. For geographical indication, there is only one office, Chennai, because there are limited applications in GI. Okay. And for patent information system, which is typically called as PIS, so it is in Nagpur, Maharashtra. So patent information system, PIS system, is a good system where you can find out all the data. Our Indian Patent Office data is managed by patent information system only, at that Nagpur office, and they offer the training also. You go through the website of that, you will find that there are a lot many training programs available. Those who wish to know, those who wish to learn, they can apply. So there are so many formats in which you can seek the training. So patent information system office is in Nagpur. So Kolkata, Delhi, Mumbai, Chennai for patenting and all, and for registration of the trademarks, one additional office in Ahmedabad. So now, so last almost 20 minutes, 25 minutes, we are talking about the patent or 20 minutes, patent. So now the way, what is the patent? How to define it? Because we as a teacher, we know we want definitions, correct? I am also expecting same. So what is that? So what is the patent? So it's a grant of exclusive right, exclusive for you only, for the creator, exclusive. It is a grant which is given, okay, the grant of exclusive right, exclusive, specific. To whom? For an, or for which reason? For an invention, right side. The grant of exclusive right which is given for an invention. Who gives you? By the government. That means government of India. To whom it is given? To the inventor. That means the person who invented that. Technical word. Now onwards there will be little bit struggling. Huh? Okay, inventor. So to the inventor. For how much period? For it is a patent. So for limited period. That means 20 years. But for that, what is to be given in exchange of full disclosure of invention? You have to disclose the invention. Now, what it is going to give you? To prevent others from selling, making or using the invention. So the clear-cut definition is it's a grant of exclusive right for an invention by the government to the inventor for limited period in exchange of full disclosure of invention to prevent others from selling, making and using the invention. So now after going through this slide, immediately a question pop-ups in mind. Sir, one side you are saying that you have to protect and one side you are saying that you have to disclose the invention. You have to disclose that invention to the Indian Patent Office and they will disclose that invention to all. Now it is very jumbling, na? but it is there. Any invention, if you have, then if you register in, once you apply, once you file some forms to the Indian Patent Office, then no one can snatch that patent from you. This is 100% sure. So once you register the application, then you can disclose that information. Basically, it is mandatory. You have to disclose the invention, and that invention will be open for public for next 18 months. Those who want to take objections, they can take the objection. Correct? This is the classical part. It's a democracy, na? It's a good part. Very healthy system is there in India. Patent office system is too good. Okay, and this is practiced all over the world. Globally, it is practiced, not only India. India is doing well, exceptionally well, but this practice, disclosure of invention, is throughout the world. So clear what is patent? Next. So now patent. So history, one should know the history of the patent also. So the patent, actually the Patent Act, how it came into picture, because we as a teacher, we know we want a detailed information, correct? So this is the history of patents. Tomorrow, if you want to share this information to your students, you must know. So now what is, if you track the history of the Indian patent law, basically Patent Act, so you have to go back into 1856. So there was a act for protection of inventions on the basis of British law. There was a typical British law, but which was designed for this protection of the inventions. So 1859, the patent monopoly is called exclusive privileges that came into picture. In 1872, Patent and Design Act was formulated. 1883, Protection of Invention Act, then Invention and Design Act that came into picture. Modern patent era started there, 1883. And 1959, there was a report by Justice Iyengar. Justice Iyengar committee was formulated, one-person committee, and Justice Iyengar submitted his report. And in 1967, that Patent Act bill came into Parliament. And in 1970, the Patent Act passed by the Parliament, which was actually enforced in 1972. But it was known as in the Patent Act 1970. Now, in 1994, there was an amendment for this EMR, exclusive marketing rights. In 1999, again there was that amendment was passed by the Parliament, and new patent amendment bill came into picture. And 2003 to 5, the Patent Act 1970 with second amendment came into force. Okay, so this is the classical trail of Indian Patent Act, where you can call it as a Patent Act 1970, which was amended in 2003-5 period. 2003 to 2005 period, and that is typically called 2005 amendment. So now, criteria for patentability. Now this is again a good slide. So many questions came into picture. Basically comes always, sir, what is patentable, what is not patentable? So this is called criteria of patentability. So there are some sections, section 1 of 2, section JA of 2, and section AC of 2. It is always reverse direction, okay? Section 2, subpoint AC, section 2, subpoint JA, section 2, subpoint 1. So where I, it is not 1, it's I, okay? So now, there are three classical terminologies one should know: novelty, inventive step, and industrial applicability. So based on these criteria, you can decide whether my idea, thought, or anything creation is patentable or not. So section 2, what it explains: inventions which has not been anticipated by publication in any document or used in the country or elsewhere in the world before the date of application. That means novelty means first time in the history. Novelty means first time in the history. Nobody has this thought. Then it is called novel. Okay. So novelty should be there. That is the first criteria. If your idea is novel, then it is patentable. 100% patentable. Then second is inventive step. Tomorrow it may happen that you do not have a novelty in your thought, but there is some technical advancement in the existing thought. That is called inventive step. Inventive step. So if your idea is having this inventive step, that means technical advancement, that also can be patented. And third criteria, which is again very important, invention is capable of being made or used in an industry. So these three criteria are very important, very, very important. Unless and until you have industrial applicability, there is no fun to go for patenting. So industrial application must be there, must be there. Then only you can go for patenting. So these are the criteria for patentability. Novelty should be there. If not, inventive step should be there, and it should have industrial applicability. It is not or, it is and industrial applicability. So now, second slide of this slide is what is not patentable. Again, we are more interested to know about non-patenting materials also. Correct? So first criteria, section 3 actually of Indian Patent Act 1970, 2005 amendment. It explains it very nicely. What is not patentable? Section 3 is typically for this, and even one part of 4. The inventions which are frivolous means it's of no use. You have just idea, but utility of that idea is not there. So you cannot patent it. You cannot patent it. So there should be some usage of the invention. Then only you can patent it. Otherwise you cannot. Then some of the inventions which are harmful to the human, animal, plant life or environment. Life-threatening inventions are not at all patentable. That is under fourth criteria also, inventions related to atomic energy. Okay, because lot many times we heard about nuclear weapons and all those, which is not patented. It is not possible to patent it. Technically, legally, it is not permissible in any country in the world. In any country in the world. So harmful inventions cannot be patented. Now, the mere discovery of new use or new form of known substance that does not result in enhancement of the known efficacy. If there is no advancement in the existing knowledge even, so that you cannot patent is D of 3, section 3. Then the method of horticulture or agriculture, it is not patentable. It is not patentable. You cannot take a patent of Fanpali, Nangardi. You cannot take it. Those who are from the Maharashtra region, they can understand these words very well. Okay. So techniques which are used in agriculture, farming, so techniques that you cannot patent, that is worldwide open book. So it is open to all. It is for all humankinds. Okay, mankind. Now, any process for the medical, surgical, curative or prophylactic or other treatment purposes. That's why bypass technology, those who have invented, we can use it. Angiography, angioplasty, anything for the treatment that you cannot patent. You cannot restrict others to use it because it is for treatment purpose. It is for the betterment of the all humankind or mankind, you can say. Then plants and animals other than microorganisms you can patent, but not plant and animal varieties, even in whole or any part, including seed varieties, species and propagation methods that you cannot patent. Mathematical formulae or a computer program or algorithm you cannot patent. But last 7 years, now there is a slight change in this part. Some of the software portions now you can patent it. Previously for software we were not having a legal framework for patenting, but now partly you can patent it. Now artistic work including music, drama, literary, you cannot patent it. Why? Because it goes into copyright. It goes into something else. It is not a part of patent. And then topography of integrated circuits, you cannot patent it. So these are the criteria. If you apply this to your thought, idea, innovation, you can come to know whether my idea is patentable or non-patentable. So now, types of the patents. Now, in patents also, you can categorize the patents like design patent or industrial design, utility patent and plant patent. So you say, sir, you are saying that previous slide, plant cannot be patented. Yes, those plant materials which are asexually reproduced, new varieties, asexually reproduced, you can patent it, varieties that you can patent it. So there are some what you can say legal places where you can, or legal spaces where that you can use it and you can patent it. Okay. Now, first of all, let us talk about the design patent or industrial design. So ornamental design, configuration, decorative appearance, shape of the invention. So that comes under design patent. So in right side, you can see top. So there is typical photograph of iPhone, Apple. So just by looking towards the phone, even from distance, you can actually recognize, yes, this is iPhone. Why? Because the outer contour is so well designed and it belongs to that particular company, and it has promoted in such a way that now everybody knows the shape and contour. If this is the shape space, then definitely iPhone. Hello, hello. Okay, so that is first part. Second, utility pattern. Any new invention or functional improvements on existing inventions, so that comes under utility pattern. Definitely, all the patents are utility patent only, because the product and the process that comes, it is the way by which you can define it, nothing else. Okay, now, types of patent applications. So, what are the types of the patent? Different patent applications. Now, up to this part, it was typical a theory part. So that's why my lecture actually states that theory to practice. So now onwards, it is a practicing session for all of us, how to file a patent, what are the typical forms, and how you can submit it, and how you can dig out the information. Now, the types of the patent applications. So ordinary application is there, those who are done by the person, a simple person, with provisional specifications or complete specifications. That means there is a provision. Basically, those who are having this idea in the mind, if you want to have a priority date, you can register it with provisional specifications, limited specifications, and then you can, over the period, you can develop it and you can go for complete specifications. That is ordinary application that can be made by the companies also. That comes under ordinary application. Now, second is convention application. Third is PCT international phase application. Fourth is PCT national phase application. Fifth is patent of addition. Sixth is divisional application. So I will explain 5 and 6 first. Patent of addition. Apart from regular patent, if you want to add some improvements or modifications, if you did it, so it is called patent of addition. In case of first patent, if you have one patent already granted, and if you want some improvements and modifications which are needed, so you can go for patent of addition. And if you want to explain something in the existing patent, then again you have to file, that is called divisional patent of the same original patent. Okay, so that provisions are there. So that means what, after filing and after granting of the patent also, you can go for improvements or modifications or else clarifications. Rest convention applications, PCT international applications, PCT national applications, these applications are for those who want to do the business in abroad. Because see, you file the patent only for the commercial use. In commerce, first slide, second sentence, last two words. In commerce, we go for patenting only to secure our rights so that we can do the business. So PCT national international phase applications and PCT national phase applications are for those who want to do the business not in India, but along with India, they want to perform or they want to do some business activities abroad also. So now, what are the patent application stages? The first application stage is filing of the application. Filing. You have to file the application. Technical word, filing. You have to fill the form, you have to submit it. Then, once you submit all the documents, then Indian Patent Office, what they will do you know? They will publish that document as such on the website. Okay, for next 18 months, that will be published throughout for 18 months, and it will be open for everybody. Anybody can access it, anybody can see it. Now question is, sir, it is my innovation or invention, I disclose it and the patent office already spreaded that information everywhere. Yes, it is there. It is because if somebody has a claim, this patent belongs to me or this invention is belonging to me, so this invention, so there should be fair chance to everybody to defend whether this patent belongs to me or that fellow. That publication is there. Then after that, after certain period, the Indian Patent Office through their patent attorney they will examine the application. Okay. They will go for examination of the application. They will send some reports to you. You have to clarify. You have to give the justification. You have to submit some of the documents. Then in some cases, there will be opposition to the patents also. Somebody, your colleague or your counterpartners or your competitors may submit a opposition to this patent. Yes, it can happen, and generally in business it happens. Those who are a competitor of each other, like food and pharma, even chemical industries, pulp industries, everybody, those who are involved in competitive market, they are always looking for the others what they are doing. So opposition is quite possible, and after crossing all these stages, the last stage will be a grant. That means your patent will be granted. Okay, so these are the classical 5 steps, patient or stages, what you can call it as a stages, 5 different stages: filing, publication, examination, opposition, and grant. Now, requirements for filing patent. This is again one of the important domains. Sir, if I want to file the patent, so what are my requirements? How do I start? So the first question, who can apply? Any person. Now I am talking about the Indian patenting system. So my overall discussion will be limited to Indian Patent Office and Indian patent system only. A person legally claiming to be a citizen of India, okay, he can actually apply, or else a group of organizations or organization can apply. Okay, so a person who is claiming to be true and first inventor, assignee of the person or legal representative of the person. Sometimes it may happen that you are not in a position to file the patent, but on your behalf somebody can actually apply. So that provision is there in Indian patent system. Okay, so anybody, those who belongs to India can apply. Now, types of filing. Physical filing is over. It is cut. Now, there is no physical filing. You have to file the documents online. Online filing procedures are there. So for that, previously for physical filing, the Mumbai, Chennai, New Delhi, and Kolkata offices were there so that you can go to that offices and you can submit the application. But now it is not that case. Now, what are the jurisdictions? For Mumbai, it is Maharashtra, Gujarat, Madhya Pradesh, Goa, Chhattisgarh. So it is central India basically. For Chennai, it is south, like Andhra Pradesh, Karnataka, Kerala, Tamil Nadu, Pondicherry. For New Delhi, it is extreme north, Haryana, Himachal Pradesh, Jammu Kashmir, Rajasthan, Uttar Pradesh, Uttarakhand, Delhi, and Union Territory of Chandigarh. And for Kolkata, northeast region, rest of the India. That is the territorial jurisdictions. Now, the case is, if you file the patent online, by default it will go to different offices. If you belong to Maharashtra, then it will not go to Mumbai office. I am damn sure, very sure. If you belong to Maharashtra, that may go to Chennai, New Delhi, or Kolkata. If you belong to Chennai, then definitely it will go to Mumbai, New Delhi, or Kolkata. It is randomization. Okay, territorial randomization. Now, technical part. What are the other things that you need while filing the applications, patent filing? Form 1, Form 2, Form 3, Form 5, Form 9, Form 18, Form 26. That is required. Beyond that, I'm going to show the form. Don't worry. I'm going to show the forms also. Certified copy of convention application if you want to go. Abstract of invention drawings. Fee. It is not in cash. Previously for physical filing, it was is cash or by local check or demand draft. Now it's online. You can pay by using Google Pay also. And digital signature. Class 3 digital signature is mandatory because now every document is to be signed digitally. So you need a digital signature. So digital signature is costly affair. Basically class 3 digital signature for 2 years, it will cost you around 4,000 rupees, 3,500 to 4,000 rupees. So it is mandatory. Whenever you submit any documents to Indian Patent Office online, you have to digitally sign that document, and where you need this. Okay. So form 1, 2, 3, 5, 9, 18, 26. So form 1 is typically application for the grant of patent, proof of right to make an application. Form 2 is provisional or complete specification. Form 3 is statement and undertaking regarding foreign application. Form 5, declaration for the inventorship. Form 9 request for publication, Form 18 request for examination. Every step you have to follow meticulously. Now see, this is the Form 1. This is a typical format of Form 1 where you apply in this typical format. So there is something like applicants, references, identification, types of application, ordinary, conventional, PCT, national phase, international phase, category of applicants. This all you have to fill. Then next page, title of invention, authorized registered patent agents if you are using that, address and all this. This is generic form, which is Form 1. Then Form 2, it is for provisional oblique complete specifications. So basic information is there, description, claims are there. If you have claims, no issue. If you don't have, no issue also. Because if it is a provisional, then claims if you don't even write, then it's okay. But for complete specifications, claims are mandatory. Okay, claims are there. Actually, real sense, you get a certification or you get a rights of the claims only. We call it as a patent, granted patent, but it is not a total patent. Basically the claims which are covered under that particular patents. Okay, that particular patent. So this is Form 2. Then Form 3 is there, statement and undertaking under section 8, the Patent Rule Act, where you have to declare something, name, address and everything. Then application Form 5, declaration as to inventorship. Who are the inventors? Who is applicant? Who are the inventors? You have to fill this form. Now Form 9, the patent request for publication. After filing a patent, then again you have to submit a written request. Kindly publish my patent. And this request for publication, once it reaches to that office, they will publish it. Okay. Then this is Form 18, request for examination. Again, after 18 months, you have to submit the form also for the express examination. Then you can request them by submitting the necessary fee and this form. Kindly examine my application and let me know queries, if any. Then you have to write it and you have to submit the fee. Every action is associated with the fee. Okay. You have to submit the sum fee. Then Form 26, form for authorization of patent agent. If you don't have that technical knowledge, legal knowledge, and if you want to use the technical or legal person, say you can appoint that person under this and you can submit the Form 26. Now, what are the differences between provisional and complete specifications? Provisional specifications means whenever you get the idea, just file the patent, just submit the application. That is called provisional. But if you are sure, if you know your invention is good, then don't worry, develop that complete application and then you submit it. That is called complete applications. So which covers claims also. Okay. So third part, for provisional specification, you don't need claims. For complete specification, you must have claims. And second point, it should describe the nature of invention and contain the description of essential features. For this provisional, and for complete application, it should describe the nature of invention, details of manner in which it is to be performed. All the details are required in complete specification. Now, contents of provisional specification: title, written description, drawings, sample or models. It is needed. What is the advantage of provisional specification? Whenever you submit, you get a priority date. The date on which you apply, that date is considered for you. So if you want a priority, then just submit the innovation immediately. Then you get extra time to develop further invention. And one more part, after some period, if you feel that it is not going to give me something in return as a business point, you can close it down. So further investment, you can reduce it in the patent filing as well as development. Now, for doing the business, commercial feasibility is quite possible. After submitting the provisional application, immediately you can talk to your business partners and you can transfer the technology. Recall your first slides, second slide, third slide. Transfer of technology, need of the IPR. Okay. Then it avoids further expenses. That is true. Now, this is the classical flow chart, content of complete specifications. A patent, what are the sections and what section actually represents what. See, first part of any patent or complete specification is title of the invention. That is first. Beyond title, then there is a field and background of the invention. You have to write to which field this particular invention belongs, and you have to describe the background of the invention also. Then third is use of invention. This is more important. There are three green boxes, okay, and it explains very well the vitality of the complete specification. Use of invention, this is one of the critical sections of the complete specification. You have to describe what is the use of the invention. After that, there is prior art in the said field of invention, that is dark gray, because most of the time the prior art in the field of invention, which is a killing document, basically the strong evidences in the prior art, which actually reduces the chances of getting the sanctions of the patents. So prior art is to be written very nicely. After that, there is a comparison between prior art and present investigation. That is not a big deal. But after that, object, aim of the present invention. What is the aim? That is more important. After that, it is a summary of the present invention, statement in the invention, statement of invention, then detailed description of the invention with respect to drawings, working examples. Up to this point, it is a flow, just like research paper. Now, the second last part, claims for legal monopoly. If you want to do a business in a specific area for a specific period, then what are the claims for the legal monopoly? And you get the grant of the claims. Although we call it as a patent granted, it is not patent basically granted, it is the claim section which is granted to you. And last section is abstract. Yeah, it is something in a reverse direction. In research paper, we write the abstract at the start, but in complete specifications of the patent application, the abstract is at the last. Okay. Now, opposition. I'm going to talk about the opposition also. So, a lot many times you may face this kind of issues where somebody may come up and somebody may oppose your patent. So, there are two classical ways by which you can do it. Pre-grant opposition. Once you file the application, so within 6 months from the date of publication, you can take the or you can raise the opposition, you can raise your voice, or else even post-grant opposition is quite possible. If the patent is granted, still you have a fair chance. Within 1 year, you can oppose it. So now, what are the issues in which oppositions are raised? Patent is wrongfully obtained by a person. Then this is right, basically, right of everybody. Wrong things should be taken into priority and should be opposed. So patent, if you take it wrongfully, then everybody has a right to oppose it. So that is one case. Invention is obvious to person skilled. That means if you do not think, you have just portrayed that application, that is also opposed. The claims do not relate to the invention, that will be opposed. And the best mode is not disclosed in the complete specification. That means you are hiding something realistic picture from the patent office. So in that case, opposition will be there. Okay, so these are the cases where opposition may happen or may take place. Now, fees, the more important part again for all of us. Sir, everybody says that for filing a patent, it takes 1 lakh, 1.5 lakh, 2 lakh. Yes, it is there. But in true sense, it is not. See the prices, see the amount. If a single person, as an ordinary person, Indian, what you can say, citizen, if you draft a patent of 30 pages with 10 claims, the individual fee is only 1000. And if your company is filing that patent, not you, a company, then it is 4 times. Every amount is 4 times, 4000 rupees, just for filing the patent. And if you have more than 30 pages, then for every page, you have to give 100 rupees. And for every claim, you have to submit 200 rupees per claim more. It is for individual, for legal entity, it is 4 times. Then request for examination of the patent 2500 rupees, request for early publication 2500 rupees. And now see the renewal fee from 2nd year to 6th year 500 rupees, 7th to 10th year 1,500 rupees, 11 to 15 years 3,000 rupees, and 16 to 20th year 5,000 rupees. The fee structure is too small, too much small for individual person. Yes, it is quite obvious. For organization, legal entities is 4 times, because companies they earn the money through business now. So official fees are more. Now, patent filing procedure in India. The flow chart, how it happens. A single slide which explains it very nicely, very nicely. Provisional patent filing, if you apply with provisional specification, it takes 12 months. 12 months is a period given to you. Within this 12 months, you have to file the complete application. Correct? After that, third stage is publication. For 18 months is the period. You have to publish that document, publish it in public domain through Indian Patent Office. Then after publication, maximum 48 months will be required for the examination. That means 4 years. It is not a 4-year period. Now it is so expedited. Nowadays, last 10 years, 15 years, last 10 years, especially last 10 years, the process is so smooth. Now it's very fast granting of the patent is possible. So those who are interested to do the business by using this intellectual property rights, we do have a very good ample opportunities in the India right now. Okay. So now it won't take 48 months for the examination. After examination, there will be first examination report which will be sent to you, and within 6 months you have to reply. Within 6 months you have to give the reply to first examination report. In technical word, it is called FER, first examination report. If you comply very well, then patent will be granted directly. If you do not comply, compliance is not there, again there will be second report. Within 6 months, again you have to reply to the second report. If you comply, then it will be in the grant position. If not, there will be hearing. Now it is just like a court hearing, legal. And court hearing, there will be patent attorney. They will ask the questions. Basically, one patent attorney, not they. Basically, one patent attorney will be there. He will ask, he or she will ask the questions. He or she will request for some detailing. If you comply it properly, then there will be a grant of the patent. If not, then at that case, they will the Indian Patent Office will straight away deny your grant. So it is quite legal framework which is there for the patenting. Okay, so this is the classical slide which explains the stage-wise processes and the period required for each process. Now at the last, if all goes well, then you will get that patented. That means your idea is patented, your thought is patented, your creation is patented. So now how do it look like? So this is my example only. So my patents are there. This is the patent certificate. So patent certificate, if you read it, there are critical areas. Patent number is there. So now onwards, my invention will be known by patent number. 372981 will be the number. Second part is application number. So application number will give you the idea. First 4 digits will explain about the year of filing, 2017. Then see the date of filing, 24/4/2017. And who is patenting? Sachin Bhusare. Okay. So at the last left side corner, you will find the date of grant, 28/7/2021. So it took me almost 4 years to bring that patent from filing to grant. But now you can expedite the process. Even within 3 years, you can manage the show and you can do it. It all depends upon how you respond to the respond for the compliance. Now, after this, the most important part comes into picture. Sir, this all is based on information. Now, what is the database that I should search for before filing the patent, while filing the patent, even after filing the patent also? So database search is very important. So purposely I kept this section. So what are the database searches? So there are so many search engines which are available. Technically, we always talk about the Google or else PubMed. It is not so simple. For images, there are 5 different types of. This is the classical slide which explains the search engines. For videos, YouTube is there, but Yahoo videos is also there. MySpace is also there. For health, you have WebMD, Mayo Clinic is there, Revolutionary Health is there. For cooking, you have all recipe, cooks.com, Epicurious. See, specific area wise search engines are available. So now it's your job to hunt the information as per your own need. So database search, if you want to search, the classical way is PubMed search, all the scientific data. It belongs to National Library of Medicine. So all those who are working in the healthcare, so please listen carefully. PubMed is the classical search engine. You can download the authentic information from the PubMed, and you can see the top website ranking, and all these images are there. Now, second information source is itself is a US patent office. Just like Indian patent office, US patent office is also there, and you can drag the information, you can track the information, and you can dig out the information from the US patent office. So it is open source document, it is open source information which is available. Third important search engine as far as patent is concerned is Indian patent office. See the snapshot of the Indian patent office. This is the classical snapshot of Indian patent office. You can access the data. Copyright office is there, and then you have this comprehensive e-filing, public search is there. If you see the right hand side first box, black box, public search is there. You click it, you'll get all the databases of the existing patents. Now see how it looks like public search. In public search also you have patent center point. Just focus on center point of the slide. Patents, trademarks, AI-based search is there, designs and electronic register of patent agents is also there. So now how to find out any patent? So there are several ways by which you can do it. See, you can search by application date, title, abstract, complete specification, application number, patent number, application country, application address, inventor name, inventor country. These all options, left side, search fields, it is available. Now top, published as well as granted. So anyone you can search, either published or granted. Granted means already published, so no issue. Those which are not granted, that you can search. And if you have an idea about the date, time period, from this date to this, that date, you can do it. So various options are there. So this is classical search of my own patent. You can see the data. Okay. So now database search, patent search. So now once you search it, the status you will come to know about this. So 380641, that patent belongs to me only, my group, research group. So it is a granted application, patent number this, and now that flow chart has been given: filed, published, archive filed, under examination, and disposed. So e-register is there. You can find out the documents, view documents, right corner. You can take out documents. It is freely available. Orders and decisions files are there. You can find it out. Now, this was all about patenting. Now, few slides I will talk about copyright and something. So for those who are into book writing, poem writing, music, drama, art, artistic work, literary work, for them it is not a patent, it is copyright. So again, there is one specific copyright website from the Government of India, Department of Promotion of Industry and Industrial Trade. So copyright office is there. So left side you can see, purposely I am sharing the screens and screenshots of the offices, because if you go to any commercial authorities for filing these copyrights or patents, they will charge you very heavily, very heavily. So better you practice it by yourself. Best part, we all are teacher and we all are teaching fraternity, belongs to teaching fraternity. So we do have that IQ, so we can do it. If I can do it, you can also do it. Okay, so now copyright office. So left side you can see online services, e-filing of copyright applications. Only thing is you have to dig out the information: registration of copyright, change in particulars, e-filing of application for copyright society. Just download the documents. The formats are available. Prepare the documents in the format and upload it. Okay, so this is very easy process, and you have to submit whatever fee applicable. So now copyright. First of all, you have to prepare your login, password and login, and then you log in yourself in your through your account, and then you have to submit. See, the procedures are given: instruction for filing copyright registration form online, how to file them. Okay, complete the form and then press save button. Every step has been written so clearly. Now last 10-15 years, India has remarkably came into picture where all the data is online available and you can read the data and you can process it by your own. You can proceed by your own. Okay. For Indian Patent Office also, filing a patent, it becomes now very easy task. But for that you must have some techno savvy approach. Okay. So now up till this part, I was talking to you for patent filing and all. This is commercial slide. This is from my department, Department of Chemical Technology. We do have Center for DMPK Studies, University Dr. Bamu, and we do have commercial line also where we used to provide the services. HPLC, LCMS, GCMS, ELISA plate reader, UV visible spectrophotometer. These are the analytical instruments which are available in the Department of Chemical Technology, and we as a Dr. Bamu team, we offer these services to the students as well as the industry also. For students, it's very minor charges are there. And we do offer services in antioxidant assay, isolation of pure phytochemicals, formulation development, analytical method development, and validation. This is official part of my university, Dr. Bamu, where we are into generation of some revenues for my university. Okay, so this is the slide. If somebody wants to avail this kind of facilities, so you can actually do it. So this is the last part. My emails are written over there. sachinsbhusare@gmail.com and sbhusare.chemtech@bamu.ac.in. So now next 10 minutes, if you want to ask the questions, so session is open for the discussion. Those who are interested, they can talk to me online, or else you can come to Department of Chemical Technology. You can talk to me. Even this session is also open for the question session. If somebody wish to ask something, I am ready to answer to the best of my knowledge. Audience, please. Anybody? Okay, so I will summarize once again what we learned last 90 minutes, 75 minutes. So it is something like patenting, intellectual property rights. That means a property that is created by your own brain. So there are different forms of the patents, intellectual property rights. Patent is one of the classical formats. Okay, and then copyrights are there, then trademark is there, industrial designs are there. So now for every format of intellectual property right, so there are typical procedures and typical offices, basically websites through which you have to apply. For patenting, Indian Patent Office has a separate web page through which you can apply. So for ordinary person, those who are a single person or Indian citizen, the filing charges are very minimal, very minimal. So you can go through the chart. My presentation is with HRDC, so you can take it from them. Then after filing, before filing also, you can go through it. And then the most important part, what are the stages of the Indian patents? What are the stages through which it crosses? So just go through it. It is bit costly affair if you seek the help from the outside agencies, but it is very cheap if you do it by yourself. Only thing is, while drafting a patent, there are issues. Technical language you must know. So what is to be done? Just go through 10, 20, 30 patents. Just read it. The patents which belongs to your own area. And just try to understand the language, Indian patents. And then you can draft the patent. Patent form 1, form 2. Every form is online available. Just download the form and try to fill the information. It is so easy. So that way you can fill the information and you can submit the form. While submitting the form, there is a CBR generation, CBR slip generation. So every CBR slip is associated with some amount, 500 rupees, 200 rupees, or somewhere like 1,000 rupees. So you have to deposit that amount through online mode. You can submit the amount and you can generate the CBR slip. That means confirmation of your submission, and keep it with you. Now, the most important part, which I faced in last 3-4 patents, is the hearing. It is just like a court hearing where you have to defend your patent. So before going for the hearing, just go through your invention, try to write a bulleted forms, okay, so that it will be easy for you while defending the patent, because they will ask some questions to you obviousness. There is one more technical term. It is available. How you can patent it? So you should be ready with these kind of questions. Your innovation or invention, anything. If you want to actually propagate to the society, then first of all you should know whether it is really innovative or not. So that's why first ask these three questions to you: whether my idea is novel, or else my idea is having innovative step or inventive step, and not or and whether my idea has a industrial application. Any idea which is industrially not applicable, if you patent it, then you are wasting your money. That's all. Because patenting anything, copyright, trademark, all these are business affairs. If you want to really go for business, if you want to earn hardcore money, then only you do it. Otherwise, for the sake of just publication, if you do it, then every year you have to submit the amount. Filing charges are there, renewal charges are there. So take care of that. Okay. So for renewal amount is quite huge. When you cross first stage, second stage, third stage, the fee gets increased. Initially 500 rupees, then it becomes 1000 rupees, then it becomes 1500 rupees. And every year on the same date, you have to fill that. You have to submit the amount. Okay. So ask yourself about the novelty, inventive step, and industrial application. Then go through the documents, fill the documents properly, submit it online, submit the fee structures, and just keep the track on your email, because everything will come on your email. You have to reply on the email. Correct. So keep a track of email. Then there will be something like first examination report. Take out that report, print out, go through it, read it carefully, try to understand what is the information they are asking for. Then go through the literature survey, collect that information, think, write the response, and then submit that response. That is called response to the FER. Within 6 months, you have to do it. Okay. Otherwise, it will not be entertained. Your application will not be entertained. So file the response. After that, they will again send you the response against your response. And then consecutive to first examination reports, first and second, there will be hearing. In hearing, it is like a court hearing where they will ask the questions to you. Then you should be able to answer that questions. Now the problem is, you may feel that I am not a technically sound person. Legal language I don't know. I may be technically sound, but legally I do not have that strength. So you can appoint your legal entity. You can do it. Okay. You can appoint legal entity for that particular period, and you can defend your patent through them, through the legal entity. That provision is also there. It may happen that we are strong enough in the technical field, but we may not maybe strong enough in the legal language, because law and legal language is entirely different as compared to technical language. Correct. So please take care of that. And once it is done, then definitely no one can stop you to get that grant of the patent. And once you get that grant, then try to commercialize it, because lot many times the challenges are to make it commercialize, to make it or to sell it to the industries. Especially in pharma, it is quite challenging. But yes, we can do. We can do. Everybody can do. All over the world, people are working. You all are working in different research areas. You can do it. And those who are interested in the copyrights, yes, obviously, write down your articles, your what you can say music part, or your literary artistic work, novels, compositions, poems, and you can go for copyright. You can publish it under that copyright. Once you do it, before publication, just register for the copyright, so that nobody can take it from you. Okay. So this is from my side. If you have questions, you can ask the questions to me. Thank you. Now session is open for discussion. If somebody is interested or somebody wants to know some information, some clarification, I am there. You can ask the questions.
Hello.
हाँ.
Good evening.
Good evening. बोला.
Just wanted to know what is the scope for the language teachers? for the pattern. Is there any scope for the language teacher?
But rather you should go for copyright, sir. For languages, na, patent will not be a suitable area for the intellectual property rights. So if you create something, now you can tell me something about your research. In what area actually you work?
Actually, my area of research is language and literature. Both
Languages and
mixing.
literature, correct.
Yes,
Languages and literature. So you are mostly dealing with the literature, existing literature, some of the meanings,
exactly.
tika,
Yes,
tipani,
sir.
nirupan, something like that. Okay.
Yes,
So you
yes,
are
sir.
trying to deduce some conclusions from the existing literature, correct?
Yes,
So
sir.
that way, if you do it now, so don't go for patent. For you, the copyrights will be a right area where you can secure your property rights. So
Okay.
copyright is the right area for you people, because for patenting it is something like product, process, or new applications.
Exactly, exactly. For
Huh.
the science, it is good.
SNT people, they can actually enjoy the glamour of patents, but for you people, all those who are into languages, those who are into art, music, drama, so
Ex-
there, if you write something, the copyright will be the right domain to secure your property rights, intellectual property rights, copyright. Okay.
Okay. Okay.
Yes, sir. Thank
Thank you,
you.
sir. Thank you, sir.
Thank you. Anybody? झालं. आता ते क्वेश्चन विचारले तर एकाने विचारला आता. ओके. बघूया. थोडं थांबूया आता. होय 15 मिनिट. काय 15 मिनिट ब्रेक? चला. थांबून टाकू. 50 minutes break. All participants.
आम्ही काय म्हणतो ते तू घरी आणून देत नाही बाकी
Okay, chalo. So, welcome back for next session. So, for today's second session, I'll be discussing with you about the human health, a perspective. So now this session will clearly explain about the scenario of the human health and its actually improvisation. So human health, a perspective, this lectures covers about the health issues, then health issues, what are the stages of diseases as per two, three different systems of the medicine like Ayurveda, allopathy, then diagnostics methods of Ayurveda and allopathy, then diagnostic method details as per allopathy, then diagnostic tests and its interpretation. Then one more important aspect I'm going to cover for today's session, that is POC, point of care testing devices. Then after this testing, I'll be discussing about the development of the medicines, drugs, that is called active pharmaceutical ingredients. Now, what is the process? For a common person, it is simply a drug, but how much time it takes as a material to become a drug? So, process of drug discovery as well as development. So, there are two different issues in this. One is discovery and one is development. Then advancement in the drug discovery and development. Then future of the drug discovery, what will be the futuristic lines of the drug discovery, and then at the last there will be a summary. So now let us start with health. So whenever we talk to each other regarding health, how is your health? Fine. That is a generic word. Okay. But there is a technicality in this health. So there are authorities which talks about the health, which actually defines the health. The topmost authority, WHO, World Health Organization. Nowadays, we all follow the guidelines of WHO, World Health Organization. It's a global society. It's an organization basically, which is represented by some of the country representatives and which takes care of the globe regarding the health. So WHO defines the health as it is a state of complete physical, mental, and social well-being, and not merely the absence of disease or infirmity. It is simply a combination of physical, mental, and social well-being. So health is clearly defined by WHO. So another line which we do all follow is Ayurveda. So again, there is a classical definition in the Ayurveda regarding health, good health. Ayurveda talks about good health. How you define it, good health? See, the good health is a state of equilibrium of the three doshas, Pitta, Vata, Kapha. So generally, Vata, Pitta, Kapha, it's a common terminology where we connect it, Pitta, Kapha, Vata, Vata, Pitta, Kapha, one and same, where the mind and all the organs of the body work in harmony. It's a synchronization between your organs as well as the mind, harmonize act, and the person enjoys peace and happiness and performs his her duty of life with comfort and ease. See the description of health in Ayurveda. WHO, which covers only combination of physical, mental, and social well-being. Instead of that, if you talk about Ayurveda, then it's a clear-cut, very minute description of the health. It's a balancing of Vata, Pitta, Kapha, and where the mind and the organ works in harmony, so that person enjoys the peace and happiness. That is one part. And apart from that, he or she does her or his duties with comfort and ease. So this is by Ayurveda. Now, one more complementary alternative system of medicine that generally followed by Indian people, naturopathy. Naturopathy. So as per naturopathy, what is health? Health is, it's a combination of 5 elements. You can track these 5 elements in Ayurveda also, but naturopathy in health definition, it is clearly written 5 elements that guides the body are normal or in harmony, and if a body is functioning according to the constructive principles of nature. This is the definition as per naturopathy. So naturopathy talks about 5 elements which are normal in the body. It is well known fact that there are 5 basic elements which are the constituent elements of the body. Okay, so it is written over there: wood, fire, earth, metal, water. So this all are in harmonized way. Combination of all is in normalized state. Now another pathy system of medicine, that is called homeopathy. So homeopathy talks about health is considered as mental, physical, and emotional well-being, which matches slightly with WHO. It's a mental, physical, and emotional well-being. At 3 level, if you are well, then it is called health or healthy. So sure. So what is the health? So it's a peace of mind with ease in the regular duties, comfort, and it is because of balancing of Vata, Pitta, Kapha or 5 elements, or mental, physical, or emotional well-being. So all the pathies, let it be naturopathy, homeopathy, Ayurveda, or even WHO, which talks about the harmonization, synchronization between 3 lines, that is one mental, physical, and emotional. Now, if we know the health, then how to define the health in the quantitative line? So there are some health indicators. So overall health of any population, Indian population, American population, or Asian population, or you can say European population. So there are some classical indicators by which you can actually measure the health. It is a way of measuring the health, the health indicators. So one first health indicator is life expectancy at birth. That means a number of years a newborn is expected to live based on current mortality trend. So you can calculate the number of mortalities, and you can track it whether this newborn baby will survive for so many years or not. How much years basically? So life expectancy at birth, that is one indicator. Even infant mortality rate. So newborn infant, classical way, newborn less than 28 days baby, and infant less than 1 year baby. So infant mortality rate, number of infant deaths per 1000 live births in year. Per year, out of 1000 live births, how many infants are dead? So based on that, you can calculate the mortality rate of infants. Neonatal mortality rate, same you can measure. Only thing is you have to consider the children under the 28 days age group. Maternal mortality ratio, that is number of women who die due to pregnancy or birth complications per 1 lakh births in a year. So that is again very important. Beyond that, we do have mortality from cardiovascular diseases, cancer incidences, diabetes, depression, disability, adjusted life years. So again, these are some of the indicators. A measurement of premature death or lower quality of life due to disability, that is another way. And the activities of daily living, ADL, the measurement of ability to self-sustain based on ability to perform daily activities such as dressing, feeding, and grooming. So these are some of the indicators which actually calculates the overall health of the population. So it is not just like that I am healthy. So you should apply some of the indicators, and then you should talk about, say, based on cardiovascular diseases, how much I am basically protected of this cardiovascular disease or diabetes or depression. So these are the health indicators which are used to measure the overall health of the society. So now, up till these 2 slides, we discussed about health definition and health indicators. Now, third part, which is very important, is health issues. In health issues, there are three classical terms which we use: disease, disorder, and syndrome. So we commonly use these terms, and we do not bother even what these terms are. Disease. Disease is a condition where the causative agents are known. That means if something happens, we know it's because of bacterial infection, it is because of viral infection, that we know. So that comes under disease. If you talk about syndrome, you do not know the basics, you do not know the causative agent. It is a syndrome where you don't know. Only symptoms are there. Now, disorder, in between that disease and syndrome, there is disorder. In disorder, it's a pathophysiological condition where there is disorganization of the overall function of the body that comes in between disease and syndrome. Sometimes the causative agents are known, sometimes causative agents are not known, but there is disorientation of the functioning of the body. So disease, disorder, and syndrome. So disease, it's a known causative agent because of which it is precipitated. Because of unknown, if it is, then it is called syndrome. So now, these health issues are at three different levels: physical, mental, and social. Left side, lower bottom figure: physical, mental, and social. So now at that three different levels, these disease, disorder, syndromes are there. So now how we can relocate, or how we can actually visualize? At physical level, it is at the level of organ, bones, muscles, physical level. If we talk about mental issues, health issues, mental health issues, physical health issue, mental health issue, then it is something like anxiety, depression, stress, which is indicative of your mental health issues. And if you talk about social health issues, then social integration, friendship, relations, that actually indicates your social health issues. These are the parameters, or these are the lines at which you can assess the health issues: physical, mental, and social. So now, once you know there are health issues at three different levels: disease, syndrome, disorders. Now, first of all, it becomes mandatory to understand your own body. What is our body? Human body. So, human body, there are different pathies which explains the overall constitution of the human body. And this is the classical part as far as Ayurveda, naturopathy is concerned. Yes, definitely. It is very well explained. Even allopathy, yes, no doubt. We do have that pathy, and we all practice that pathy frequently instead of Ayurveda, homeopathy, or naturopathy. And in latest system of medicine, that is allopathy, again, human anatomy, physiology is very well explained, no doubt. But in this session, we are going to compare Ayurveda, homeopathy along with your normal pathy, that is allopathy. Okay, so first of all, it becomes necessary to understand what Ayurveda says about human body. So human body, as far as Ayurveda is concerned, so it talks about seven dhatus, sapta dhatu, technical word, sapta dhatu, seven tissues, dhatu, tissues. So it starts with Shukra, reproductive system; Majja, that is bone marrow; Asthi, that is, bones, bone tissue; Meda, fat and connective tissue; Masa, muscles; Rakta, blood; and Rasa, tissue fluids. So these are the seven tissues or Sapta Dhatus. Human body is composed of all these. And if you look into the figure, you will immediately recall, yes, definitely. Yes, these are the seven elements. Rather, you can call it as elements also. Technical word, Saptadhatu, or seven tissues. It's a composition. Overall body is composed of all these seven. So reference is written at the bottom. You can go, you can track the reference, and you can read more about this. Okay. Now, we are talking about the Ayurveda first. So once you know the body, human body, what are the different stages of the diseases as far as Ayurveda is concerned? So what Ayurveda talks about diseases, because there are stages, various stages of the diseases. So as in few slides back, 2 slides back, we discussed about it's a balancing of Vata, Pitta, Kapha. These are the three doshas, three dosh. Okay, so it's a perfect balancing of Vata, Pitta, Kapha. These doshas will exist in the body, no doubt. Only thing is the ratio of that doshas, three dosha, Vata, Pitta, Kapha, and balancing. That means equilibration is more important. So before discussing the stages of the disease, one should know the exact home locations of this dosha, Vata, Pitta, Kapha. So Ayurveda explains it very well. You can go through the blogs. It is written over there at the bottom. So references are there. So you will find frequent references in my presentation. The information which is picked from the various locations, the references are given. So you can cross cross reference it, check it, and you can verify it. Even you can enrich your knowledge. So Vata is concerned, regarding Vata, the home location of Vata is colon, pelvis, pelvic organs besides thighs, skin, ears, nervous system, and lungs. For Kapha, the home location of Kapha is bones, muscles, and tendons. And for Pitta, it
कुठे
is
गेले किशोर भाऊ
माईक माईक चालू आहे 29 नंबर माईक बंद करा.
कोणाला नंबर आहे 64 नंतर इथं डायरेक्ट 67 आलाय ना. 64
रोल नंबर 29
इधर हो.
माईक.
ते कॅप सेंटरला ते संजय पवार वगैरे कोण आहेत त्यांना म्हणा मॅडमला गठ्ठा चेक करायचा एक पेपरचा ऍबसेंटी का प्रेझेंटी तर तिथं येऊन चेक करायचं पण त्यांना म्हणा ते उघडा आणि लगेच मला जायचं चेक करायला. एफ वायचा आहे का तो एस वायचा एक ऍबसेंट आहे ना त्याच्या मी किती वेळ ते घातला त्याच्यामध्ये शोधते प्रेझेंटी शोधते.
मॅडम तुमचा आवाज येतो इथं सगळीकडं 29 नंबर
ओ सॉरी सर.
सगळं इथं ऐकू येतंय. माईक बंद करा प्लीज. ज्यांचे कोणाचे माईक चालू आहेत ना बंद करा. दिस इज सिन्सियर रिक्वेस्ट. यू आर डिस्टर्बिंग अदर्स मॅम. प्लीज काइंडली मेक इट म्यूट. Okay, so home location for Pitta is something like small intestine, stomach, liver, spleen, gallbladder, blood, sweat glands, subcutaneous fat, eyes, and skin. So now, as per how या slides वर कोणाचं तरी मार्किंग येत आहे. Don't try to figure it out. Somebody is there who is writing on the slides. Okay, so Vata, Pitta, Kapha. Then how it starts? So disease progression, it is well explained by the Ayurveda. First of all, there is an accumulation of this Vata, Pitta, Kapha at a particular location in the body. Then it aggravates elevation of the levels of these three doshas. Once it crosses certain level, then again it disseminates. So dissemination is there. That means it propagates into other tissues, and again it will go and localize there in other tissues and other parts of the body. And once it is delocalized and once it is again relocalized in the particular tissues, it will manifest. It will try to start, or it will try to show its effects, manifestation, and then it leads to chronicity and disruption. So Ayurveda clearly says about the imbalancing of Vata, Pitta, Kapha and how it happens. So now stages of diseases as far as allopathy is concerned, because I am parallelly showing you all the data, allopathy as well as Ayurveda. So in allopathy, there is a stimulus, maybe internal, maybe external. Sometimes autoimmune disease where your own antigen antibody reaction in the body itself, or antibodies actually. Type 1 diabetes is classical example of that, where it is autoimmune triggered problem where the body antibodies of our own body kills the insulin producing cells. So internal stimulus. Even COVID-19, external stimulus. So internal or external stimuli is there. It alters biochemical process parameters in the body. And once there is an alteration in the biochemical processes, it leads to anatomical and physiological changes yes? And that leads to discomfort. Classical example is your acidity. Its stimulus is external or internal. So acid secretion is up, then it leads to stomachache and body ache, headache, and then you feel vomiting, nauseating, and then it will produce its symptoms. Like then there will be, if it is very much aggravated, you may have vomiting, or else you may have heartburn, stomach burn. Okay, so in allopathy, it is a stimulus which is from internal or external source, doesn't make any difference, and this is the progression path by which there is a development of the disease. Now once there is a disease, how to actually identify. So diagnostics is very important. Diagnostics is very important. So now there are two aspects of diagnostic methods which are used in Ayurveda. So first is Trividh Pariksha, Trividha. That means three different modes by which you can do the Pariksha, Trividha Pariksha. First is Sparshan, that means touch. You can sense it by touching. Second is your Darshan, that is called visualization. Okay. And third is Prashna. Roll number 43. स्लाइड्स और कौन लेता है? रोल नंबर 43. हेलो, रोल नंबर 43. रोल नंबर 43 कौन है?
गुड आफ्टरनून सर. सर मैं सर स्लाइड ओपन करी थी, उससे हुआ शायद वो सर. मैं लिख रही नहीं थी, मैं देख रही थी सर स्लाइड ओपन करके.
मैडम प्लीज टेक
मालूम नहीं था सर मेरे को ऐसा हो जाएगा करके.
इट इज
मैं
डिस्टर्ब.
स्लाइड देख रही थी सर.
आप
सॉरी सर.
लॉग आउट करके लॉग इन कर दो. आपकी वजह से स्लाइड्स में सारे मार्किंग्स आ गए ना मैडम. ये मुझे भी
सॉरी सर.
नहीं, इट्स ओके, नो प्रॉब्लम. So something is there. You just quit and then you re-log in, rejoin.
यस सर.
Trividh Pariksha. It's a Sparshan, Darshan, and Prashna. Now, beyond that, there is one more clear-cut diagnostic method of Ayurveda based on Trividh. This is more exhaustive method where it starts with Nadi Pariksha. So you can actually sense and you can go for Nadi Pariksha, then Jiva Pariksha, then third is Shabda Pariksha, Sparsh Pariksha, Drak Pariksha, Akruti Pariksha, Mutra Pariksha, and Mala Pariksha. So Nadi, you know it. Then Jiva, that means tongue examination. Shabda Pariksha, yes, Uchcharan. Sparsh Pariksha, Sparshan, by your naked hands, you can sparsh and you can sense it. Drak Pariksha, you can observe the eyes of the patients. Akruti Pariksha, yes, overall body, text, body posture and all. Mutra Pariksha, Mala Pariksha, it's very common. So this is called Ashtavidha Pariksha. Ashtavidha, that means 8 different actually ways by which you can examine the patient. Now, in allopathy, it is different story. In allopathy, it is a different story. Diagnostic methods. कुठेतरी स्लाइड्स वर लिहिलेलं आहे, हे जरा बंद करून हे करायचं. 43.
सर अभी मैं नहीं हूँ सर.
ओके मैडम, हो गया वो मुझे क्लियर करना पड़ेगा ना. Okay, so in diagnostic methods of allopathy, so it starts with cellular and chemical analysis. So physical and visual examination is first part. Second is cellular and chemical analysis. Third is diagnostic imaging. So imaging is used for the diagnosis. Then genetic testing, and the last one is measurement. So in allopathy, it starts with physical and visual examination to measurements. So now every aspect, every corner of this slide actually represents one typical era. Now we are going to see that. Cellular and chemical analysis. So when it comes to analysis of cellular fluids and chemicals, so amniocentesis, blood analysis. So everybody knows it very well. Some of the parameters I am going to read for you people. For blood analysis, yes, blood count, blood type, AB positive, AB negative. So positive, negative, you can A, B, and O. Bone marrow aspiration, enzyme analysis, hematocrit, inulin clearance, serological testing, and thymol turbidity testing is there. Beyond that, gastric fluid analysis. Now, everybody knows about KFT, kidney function test, LFT, liver function test, lumbar function test, pap smear for the female patients. Then prenatal testing is there, thoracentesis is there. So this all aspect, left side first column. So cellular and chemical analysis. These are the different types of the chemicals analysis which are available. Now right side corner, if you look into that, it's a diagnostic imaging. Diagnostic imaging. So imaging means what? You capture the image and analyze image for the diagnosis purpose. So angiography is the classical way or classical small example where you can immediately find. You run the fluorescent dye in the vein and try to locate that whether it is blocked, where in what location it is blocked. Angiography is very common actually diagnostic imaging tool. We always consider that for the heart, but it is not always heart. Angiography is a general criteria. Cerebral angiography is also there. So you can actually track the veins of the brain also. Okay, small blood vessels of the brain also. Brain scanning is there. Echoencephalography, magnetoencephalography is there. Cholecystography is there. Echocardiography is there. Tomography is there. Ultrasound is very common. Everybody knows it. So these are the diagnostic imaging purposes, imagings which are used for the disease prediction. So now this slide purposely I kept it here. So lot many times there is a question that sir, what is the meaning of CT scans? What is the meaning of MRI? When to use CT scan? When to use MRI? When to rather understanding what type of scans we should go for. So left side corner you can see soft tissues, bones, contrast, brain imaging, spinal cord and joints. So based on this you can see CT scans for soft tissues, it's a limited resolution for the soft tissues. But if you want a soft tissue damage, if you want to track, so MRI is the exceptional details of soft tissues. So MRI is the right technique where you can actually soft tissues you can relocate and you can identify. Imaging is very good in that. For bones, CT scan, good visualization of the bone structure, but MRI will not help you there in bones. So that's why for bones, CT scan is there. So that's why skull and all those. If you want to look for the skull injury, it is CT scan. But if you want to go for the internal parts, apart from the skull, then you have to go for MRI. This is the difference. We being a common people, we should know this difference. CT scan, MRI scan, contrast, lower contrast between the different soft tissues and high contrast for the MRI. Brain imaging, less detailed picture. CT scan will not give you the brain imaging, and for MRI you can use MRI for the brain damage. So skull damage and brain damage, these are the two different issues. For skull you can go for CT, but for brain you have to go for MRI, correct? Then spinal cord, limited visualization of the spinal cord. If you use CT scan, for MRI it is clear depiction of the spinal cord anatomy. And for joints, again CT scan will not help you. For MRIs, yes, definitely MRI will help you there. So cross reference is there, you can check it out. So this is the little bit difference between CT scan and MRI. Lot many times we come across situation where we try to understand the different terminology scan modes. So this is little bit attempt to make you aware where to go for CT scan and where to go for MRI. So now continuing that, genetic testing is also a part in allopathy. Complementation test is there, fluorescence in situ hybridization there is there. Then for measurements, yes, definitely lumbar puncture technology is there, phonocardiography is there, semen analysis is there. Then if you talk about physical and visual examinations, now very important, autopsy, biopsy, dead, it's a postpartum, postmortem sampling is called autopsy, and biopsy is from the person or the tissue which is living, live tissue. Escalation is there. Bronchoscopy is again there. If you want to track something, bronchoscopy is mandatory, where if you want to see any resistance in the airway passage, so bronchoscopy will help with that. Endoscopy, again, if something is wrong with the stomach, esophagus, upper alimentary canal, or you can say intestinal part, so there endoscopy will help you. Endoscopy from by using endoscopy you can actually see the structural or anatomical changes in the little bit esophagus part, lower part of esophagus, then stomach. Specifically, endoscopy is used for the stomach lining, specifically for anatomical alterations in the stomach. Then Rubin test is there, skin test is there, uroscopy is also there. Sometimes uroscopy is needed to find it out the criticality in the kidneys and the urethra. So now, what are the diagnostic tests that are most preferred? Now we know what is the disease progression. So what are the classical tests that are preferred, mostly preferred? So commonly preferred tests in the routine part is
तेरा
hemogram.
ब्लूटूथ बंद करना आईपैड का। मैंने ये डाला तो उधर का आईपैड चालू हो गया है।
Blood fasting sugar, postprandial sugar, then routine analysis of urine. More importantly, lipid profiling. Those who are crossed 40, again, lipid profile is very important. Serum creatinine, kidney function test, then AGPT. Yes, it is there. Chest X-ray, stress test. These are the common actually diagnostic test, which if you perform, then you can be healthy. Then abdominal pelvic sonography. But sonography like part, which is needed only when if you do not have clear-cut understanding about the root causes. So there you can go for sonography. Then vitamin B12, D3, uric acid, thyroid function test. So this will help you to find out the deficiency, especially B12, D3. Then pap smear for female. Yes, again, prostate specific antigen for male. And the two classical green colored diagnostic tests, consultation by MD physician and gynec checkup for female yearly. This will help you. It's a health check, basically, health check. So if you want to track your health, if you want to track the trail of your health, then these common tests will help you. So now, more into this common tests. Lot many times it happens that actually we try to understand the standard levels and we try to deduce inference out of that. So this is a little bit attempt from my side to make you aware that what tests are there, what are the standard values of the test or markers, and what is the inference. So blood clotting time, that is clotting time and bleeding time. These are the two different time intervals or timelines which we use to see in how much time the blood gets clot and how much time it is taken by the body to stop the bleeding, a small cut. So this is the difference. So if clotting time is more, hemophilia, delay in clotting. If bleeding time is more, thrombocytopenia, low platelet count. These are the inferences. Now about blood pressure. So in blood pressure, healthy blood pressure, in healthy person it is 80-120 mm of Hg, systolic and diastolic. When heart is in relaxed condition, that is called diastolic, and heart is in contraction condition, that is called systolic. So systolic and diastolic. So in diastolic it is something like 80, and in systolic something like 120. But again, it depends upon the age of the patient and overall health of the patient. 80-120 is a standard parameter, but there is plus minus line. If you cross 40, then it will not be 80-120. You may get 90-135, 90-140. So if you consider your age, lipid content, triglycerides, cholesterol, then there will be slight change in your blood pressure, and that is an indicative of something else is happening. Okay, so keep this thing in mind. Now hemoglobin count. Yes, for males it is 14 to 18 gram per percent. For female 13 to 16 gram percent, and for children it is 10 to 13 gram percent. The level, if it is below, then definitely it is anemia. RBC count is less or hemoglobin is less. That means oxygen carrying capacity of the oral blood is less. So those who are anemic in nature, they will not have ability to run for the longer distance. They will not have ability to work hard because oxygen carrying capacity of the blood will be very less. RBC count 4.5 to 5.5 million per cubic mm. So low is erythropenia, high is erythrocytosis. Then WBC count, again, neutrophils, eosinophils, basophils, monocytes, lymphocytes. Now blood sugar, again, this is one of the most important parameter. Standard blood sugar Depending upon your condition, it is 70 to 100 mg per 100 ml. Okay, so fasting sugar, you may have something like 70 to 80, and postprandial, you can have 100 and 110. So low, the standard values, if it is low, then hypoglycemia. If it is more than the control limit, then it is hyperglycemia. Now cholesterol, 150 to 240 mg percent. So 80 to 100 gram percent, it is less hemolytic jaundice. Above is kidney disease, heart disease, liver disease. Just try to figure out some of the important parameters and their values. Then it will be easy for you to understand. So blood sugar, cholesterol, that everyone should know. Rest for the KFT, kidney function test. So for this renin, then sodium, potassium, calcium, phosphorus, alkaline phosphatase. So aluminum globulin ratio, creatinine clearance. So these will indicate about the overall health of the kidney, blood urea nitrogen. So creatinine is the marker of the kidney function. Second, in KFT, just go through second line, creatinine. So 0.3 to 1.4 mg per deciliter is the creatinine level. So this creatinine level, if you track, then it will give you the overall health of the kidney. Now, liver function test. Now, the KFT is first, then LFT. In short form, LFT, liver function test. Liver function test in ALT, AST, ALP, these are the three classical markers: alanine transaminase, aspartate transaminase, and alkaline phosphatase. So levels are given 7 to 55 units per liter, 8 to 48, and 40 to 129. So it indicates basically there is fluctuation in the ALT, AST, ALP. Then it will indicate whether your function, liver function is proper or not. Then albumin and total protein, bilirubin is also one of the indicators, and GGT, gamma glutamyl transferase. This is one of the important enzyme, 6 to 61, 8 to 61 units per liter. So it indicates about the liver damage also. So overall, if you want to know about the overall health of kidney, liver, so these are the marker compounds and these tests are markedly available. Okay, so when you give the blood sample, so you can ask for liver function test and kidney function test, and some of the parameters definitely it will be on your paper and with standard values, those which are obtained from your blood samples and with reference values also. Now, next to that is heart function test. The clear-cut indicator of heart function test first is cholesterol, 150 to 200 mg per deciliter. But one thing is there, it is not always that total cholesterol, overall cholesterol level is bad for the health. In cholesterol also there is low density lipoprotein, high density lipoprotein. One is bad cholesterol and another is good cholesterol. So high density lipoproteins are good cholesterol. So 40 to 60 mg per deciliter. So that is the value. For low density, it is below 100 mg per deciliter. So LDL should be within the limit, LDL. So if you want to see the overall health of your heart, so just track LDL. Then triglycerides, it should be less than 150 mg per deciliter. Lipoprotein, apolipoprotein, fibrinogen, these are values and these are also the indicators. But for heart, if you want to see about the functionality, so yes, just track your cholesterol and LDL and HDL. Now, one more important parameter which is of more concern to the Indian population, because almost all population is under threat of diabetes, that is hemoglobin A1C, HbA1c. It is called HbA1c or HgA1c. So HbA1c. So hemoglobin actually 5.6 or less than that. If you crosses the 5.6, then it goes to the pre-diabetic, 5.6 to 5.89, and beyond that it is typically a diabetes condition. Again, insulin is one of the marker compounds and 1 to 24 units per ml. If the value goes well below this range, then it is type 2 diabetes, okay, insulin independent diabetes, and above it is weight gain and hyperinsulinemia. Now let us go to the pancreatic function test and GI functional test. So marker compounds are potassium, calcium, blood urea, hemoglobin, serum amylase, serum sodium. Now pulmonary function test, spirometry, that means lung capacity. So ability to inhale and exhale, force vitality, vital capacity, These are the tests. Lung volume 6000 ml, 4 to 6 liter is the standard lung volume of the adult healthy human being. So if it is less than that, then restrictive lung diseases, less alveolar pulling, the lungs airways open. So there are issues in the lung airways. Then MIP and MEP, these are the two indicators, maximal inspiratory pressure and maximal expiratory pressure. Those who are having this asthmatic conditions. So MIP and MEP parameters are very important. Okay, so just go through it. Okay, I know you cannot remember every values, but just try to understand what are the tests and which signifies which dysfunctions. Now, again, interpretations, immunoglobulins, adenosine, ammonia, then cholinesterases, hemocytin, iron, magnesium. So as far as iron is concerned, for male, it is 40 to 120 microgram per deciliter, and for females, 39 to 149 microgram per deciliter. Microalbumin, pyruvate, and all this is there. So now, once it is clear now, the next lot comes into picture, the point of care testing devices. Now, whatever parameters we discussed, that needs specialized equipments like ELISA analyzer or blood analyzer. But there are some testing equipments which will help you at your bedside. That is called point of care testing devices. So the classical examples of this POC, point of care devices, is digital thermometer is there, blood glucose meter is there, blood pressure monitor, pulse oximeter. All these four POC testing devices, I know everybody, including me, it is with us, because post-COVID, now we are very much into this critical analysis, and where we try to find it out the any emergency situation and any up and down in the parameter by using this either thermometer or glucometer or pressure monitor or pulse oximeter. So now uric acid testing machines, cholesterol checker machines are there, ECG machine is also there. You can get handy ECG machines nowadays. Blood analyzer is there. Again, COVID-19 rapid antigen self-testing kit is there. Pregnancy test kit is there, and malaria detection kit is also there. So point of testing care devices, not only equipments, but the testing kits are also available, which will give you the overall indicator of the body. Okay. So now this slide I purposely actually showing here. I'm showing it here purposely because lot many times there is a question that, sir, we do have variety of point of care devices. Who is the best? Which companies are best? I'm not claiming that these are the best companies in the world, but yes, these companies are the leading manufacturers of these devices, leading manufacturers. So that means they have good sell. I'm not a company person, okay? Don't misunderstand. Just I'm trying to tell you the devices and the current market leaded by the manufacturers. So alcohol meter, cardiac markers are there, pregnancy test kits are there, glucometer. Dr. Monopen is good in point of care devices. Then blood analyzer like a biosystem is there, ECG, BPL cardiac. This is one of the good companies. Blood gas analyzer, Siemens, EPOC, arterial manufacturer is good in this. Pulse oximeter, BPL medical technologies. So there are so many companies, but these are the leading manufacturers of this point of care devices. Okay, digital thermometer, STC infrared thermometers, these are the good one. Pregnancy test kits, recombinant laboratories, again they are doing well. Lot many companies are there. You can prefer any companies. Only thing is you have to make sure that these kits or the instruments are validated one. For the instruments, it's a calibration, and for the kits, it's a validation, because performance depends upon these two parameters. Okay, thank you. Now, after diagnosis, what comes in the picture? So after diagnosis, now up till this point, what we were trying to understand is what is health, what are the health indicators, how the health perspective is of Ayurveda, allopathy, then diagnostic methods. Then in diagnostic methods, we learned a lot about the testings, biochemical parameters, where we discussed even imaging, where we discussed So now after this, when it comes to diagnosis, then we know point of care devices are with us. But after diagnosis, what is next? Then it comes to medical treatment. So these are the three classical basically representations. So left side top corner is medication, oral medications are available. Okay. Bottom side left is injectables. So these are the two different dosage forms: oral dosage form, solid oral dosage form, and injectable, liquid injectable form. And in some cases, what you need is surgical treatment, extreme right photograph. So oral medication may help you, intravenous or intramuscular injectables may help you, or else in medical treatment, the core one more major portion is of the surgery, where you try to remove some of the parts which are deteriorated or which are non-functional, so that you can remove. So medical treatment covers all these three aspects: medication plus surgical process. And in medication, you may have oral medication or intravenous medication or intra arterial medications, so and then surgical procedures. So now, when we talk about the medical treatments, the first and the foremost important part which comes into the picture is drugs. Drug is not that much technical term. Technically, it is called active pharmaceutical ingredient. In pharmaceutical language, it is API, active pharmaceutical ingredient. API. A stands for active, P for pharmaceutical, I stands for ingredient, API. So there is a definition. US FDA defines it. What is drug? If you call any substance as a drug, that means what is the classical definition of the drug? So technical term, a substance recognized by an official pharmacopoeia or formulary. That is one aspect. A substance intended for use in diagnosis, cure, mitigation, treatment, or prevention of the disease. That means a substance you can use it for diagnosis, even for treatment, cure, mitigation, complete removal, treatment, or prevention of the disease. Third, a substance other than food intended to affect the structure or any function of the body. Structure and function of the body, that is also called a drug. And a substance intended for the use as a component of a medication, but not a device or a component, part or accessory of a device. So all these parameters covers a drug. US FDA clearly defines it. US FDA reference is there. So glossary, you can go to glossary section of the US FDA and you can find it out what is the meaning of exactly the drug. So now this drug, when it comes to sources of the drugs, so there are three classical sources of the drug. One is synthetic, another is semi-synthetic, and third is natural. Now I will make it simple. So these three classical examples are given. For synthetic, the classical example is paracetamol. For semi-synthetic, paclitaxel, and for natural it is morphine. So now how it is and what it is basically. A drug molecule, if you synthesize in the laboratory by using some chemical reactions, 3, 4 step, 5 step, 7 step, those who belong to science and technology, especially chemistry, they understand very well. Synthetic means you can prepare it in the laboratory by using some chemical reactions. So synthetic. So that molecules are called synthetic APIs. Now semi-synthetic, that means a natural component which you take it from the natural sources and modify chemically. Chemical modification is done in the laboratory. Then it is called semi-synthetic. And some of the chemicals we generally directly isolate from the nature itself. And in nature, the most abundant source is plant. So from plant, you can take out some of the molecules as a drug only. Okay. So these are the three classical sources of the drug: synthetic, semi-synthetic, and natural. So these examples are there. So now let us discuss about discovery process. So I purposely kept this slide here because it seems that, or we generally call it as drug, it's very cheap, simple, no issue at all. No, it is not like that. A material, when it becomes drug, do you know how much time it takes, how much money it takes, and how much human efforts it takes? So now this slide will explain it very nicely. A molecule become a drug let it be from synthetic, semi-synthetic, or natural. The journey of that molecule starts and it ends as a drug, say after 15 to 16 years. So see the how much time it takes for a molecule or a chemical to become a drug or to become an active pharmaceutical ingredient. Now question comes in mind, sir, why so much years are taken? Why it takes so much time? Any chemical you can use it as a medicine? No, it is not so simple, because it has to pass through several stages. Okay, so there are two classical stages. One is preclinical and another is clinical. So now just look into the figure, just focus. So first, target ID, target to lead to candidate, and preclinical. So these four boxes, this explains the process of IND filing. That means the testing of the material in the animals. And beyond that, from the dark yellow color, phase 1, phase 2, phase 3, phase 4, these are human trials. So now a molecule is first tested in animals, and secondly, if found suitable, then only it goes into second stage, that is called human trials or clinical. So preclinical development and clinical development, these are the two classical parts of any drug development process. So now you see, it starts with identification of the target and validation of the target. I'm going to talk about that also. That means you try to figure out on which disease you want to develop a material. So find out that disease, find out the receptors, then find out some of the chemicals, synthetically, semi-synthetically, or natural, which may act on this target. Then out of this, select few which can become a lead molecules, and then test them in the animals and try to see whether these molecules are safe in the animal or not. Now in animal studies, safety is the most important part. First of all, we try to check the safety, because if molecule is very active, say suppose developing a material which is anti-cancer in nature, it is showing good activity, but it is not safe. Are you going to use it? Forget about cancer. Just talk about the medicine which is anti-inflammatory or analgesic, painkiller. Let it be painkiller. So that material is showing the good painkilling activity, but it is not safe. It is showing some side effects. Are you going to use it? Obviously not. So preclinical development, we try to figure out the safety of the molecules, and then if found safe as well as efficacious, then this molecule goes into human trials, phase 1, phase 2, phase 3, phase 4. Now see the attrition rate. The bottom line 60%, 50%, 40%, 40, 30, 60, 70, and 10%. So now do you know what are these figures? This is the attrition rate. That means if 100 molecules, you start with 100 molecules in target validation, 60% molecules gets out of this box. If you validate the target, 50% will go out. If you try to find out the lead compounds, amongst that 40% will again go out. And those molecules which are remaining for preclinical development, again there will be 40% reduction. So if you look into this history, do you know, if you start with 10,000 molecules, only one molecule has a chance to become a drug. Now think about the attrition rate. It is very difficult process, very tough process. And now, as it is involving animal studies, cell line studies, even human beings, okay, phase 1 trial, first in humans, phase 2 trials, proof of concept, phase 3, multi-centric trials, phase 4, post-marketing surveillance, a cost is involved. And see the cost line. $1 million, $2 million, 1 million, 6 million, 4 million, 13 million, 20 million. You make it a total, it is in trillions, it goes into trillions. One molecule, development of one molecule as a drug, it involves so much of the cost. It is in dollars, not in rupees. It is very tough to develop any material as a drug. Very tough part. Okay. So this is drug discovery and then development process. So from knowledge to validation of the target, from the validation of the target to lead compounds to candidate molecule, then which drug is safe in animals, it goes into humans first. Drug safe in humans, then it goes into drug effectiveness in humans, and then large scale trials will be there, and your proof of efficacy of the molecule will be developed. And then approval will be given to that material, and that approval will be at two different stages. Preclinical stage approval is different and clinical stage approval is different. So it takes 15 to 16 years, trillions of the dollars, and huge manpower needs to be involved to complete all these studies. So now, drug development and discovery process, basically it's a combination of three domains. One is mind plus machines, then human brain is of course needed and machines are needed. Second is computers. Nowadays we involve computers. We actually figure out how computers are helpful, and yes, computers are playing very important role. And third domain, which is into drug discovery and development nowadays, it is artificial intelligence, AI. So now we are taking the help of both computers, AI, as well as mind plus machines. So mind plus machines, here it is not only the human brain, but what we need is different equipments, different machineries. So if we club mind and machines together for the drug discovery, then it becomes very easy to come to conclusion. So when you talk about the machines, analytical equipments are there, manufacturing equipments are there, okay, testing equipments are there. And when it comes to mind, that means thought process, how you are going to use these machines, how you are going to deduce the data. It's a mind and machine. So combination of this mind and machine in drug discovery, it actually accelerates the drug development process. Okay, so last slide I explained how a molecule can become a drug, how much time it will take, how much amount it will need to get developed as a drug. So in that, if we combine the mind and machine in drug discovery, then the development process can be accelerated very well. Now, second part, when it comes to computers in drug discovery, those who are into computational sciences, so those who are having computational background, they can understand very well. Nowadays, we do have softwares where before going for any experimentation, what you can do is you can fix the structures in the softwares, different softwares, and you can figure out the absorption, distribution, metabolism, elimination, toxicological profiles. You can predict basically. No need to go for experimentation. You can save the time in the laboratories. Yes, just by using computer chips, you can do some of the studies, and these studies are called in silico studies. I repeat, in silico studies. That means by using computer chip or by using chipset. So by using this, we can actually go for drug discovery studies. So how it is helpful? Yes, definitely. See, now in this figure, now it's a combination of AI plus computer. Okay. Now here in this slide, I'm not going to highlight the role of computer, although it is shown there. Now I'm going to highlight the role of AI in drug discovery. So if you have different molecules, molecular structures, so AI technique will combine it and it can generate candidate drugs for you. De novo design it is called. Quadrant, left side, topmost quadrant. So AI can help you. AI can combine the molecular structures and come up with some of the lead candidates or candidate drugs. Now, right side top, target structure prediction. So sequence is there. If you submit this data to the computer through AI technique, actually you can predict the structure of the protein or peptides. Structure of proteins or peptides you can estimate or you can predict. Now, right side bottom, drug target binding affinity. You have drug molecule, you have identified a drug. By using computer and the AI technique, we can predict whether my molecule is going to fit into that target or not. And if it fits, that means what kind of interaction, left corner left, drug target interaction, that can be studied by using AI. So AI is nowadays playing a very important role with combination of computers and AI. Now drug discovery process can be speeded up, can be strengthened, can be initiated, and can be moved further in a fast way. So now AI in drug discovery. So in AI in drug discovery, this figure is very important, where you can say stage 1, stage 2, stage 3, and stage 4. Stage 1 is the basic research where you can have 5,000 to 10,000 compounds, synthesis, optimization, and in vivo models. Then stage 2 preclinical phase, where toxicology studies are there. Out of 5,000 to 10,000 compounds, only 5 compounds may enter into stage 2 preclinical. And in stage 3, after 8.5 years, phase 1, phase 2, phase 3, after 10.5 years, drug repurposing, selection of patient population, adherence control, And regulatory phase, it takes 14 years, and stage 4, 1.5 to 2 years, phase 4, one approved drug, pharmacovigilance. So all these processes can be aligned with the AI in the drug development. So right side, you can see identification of new targets. It is easy by using the AI. Then prediction targets role in the disease. AI will help you there. And the prediction of signaling systems. Yes, definitely. So prediction of new compounds, prediction of ADMT, prediction of synthetic routes, prediction of toxicology, drug repurposing, all these parameters, pharmacovigilance, that can be done by using AI. So now you can see the role of the AI in the drug discovery. Although manual work is there, but AI can help you to pinpoint the data sets. So now, what is the future of drug discovery? Again, this is one of the important slide where you can see. So how it happens basically, now we do have cloud computing, we do have data integration systems. So you can see the combination of data and instructions when it comes together, and if you store it in cloud computing, so you can process the data by using population pharmacokinetics population data sets, and all these clinical data sets, when it is combined in the population data, human knowledge, historical patient data, increasing technological clarity, biomarker explosion. So combination of all these along with the deep learning, predictive analysis, translation, then speech, vision, language processing, natural language processing, or even machine learning. All these aspects with artificial intelligence, they will generate the instructions also. And that again recombine and you can put it into cloud data. So in drug discovery, the future is very actually what you can say impressive, where some of the human interventions can be minimized by using AI as well as deep learning, machine learning, and accuracy and what you can say precision will be highest when it comes to use of machines. Yes, definitely. Ultimately, if your machines are well calibrated and accuracy and precision is defined, then obviously the output which you are going to get will be definitely a precise output. So now, future of drug discovery. Again, how? So there are fast track designations are there, accelerated approvals are there, breakthrough is there, and priority reviews are there. So I am going to talk about this for few minutes. So now in drug discovery, there are some situations where this approval processes are also speeded up. So the classical example is COVID vaccine, COVID-19 vaccine. In COVID-19 vaccine, we developed that vaccine within that stipulated small period, and we came up with a vaccine within 1 year, which was available for all the human beings. So there, the approval processes were accelerated, and it was promoted so that so that lives can be saved, saved. And now you see the miracle because of COVID-19 vaccine, it was a breakthrough in Indian market as well as abroad. And India led that vaccine development program. So we are giant in vaccine development program. And why it is possible? The accelerated approval processes where you can accelerate the approval processes. Some of the safety data, basic data, if it is clear, then you can move it fast. Fast track designation, drug intended to treat serious conditions, preclinical or clinical data required to demonstrate potential to meet an unmet needs. So yes, just fix whether it is going to give you the effect or not, then fast trackly process it, approach it, and then breakthrough. Drug intended to address the serious conditions, just go through the drug profiling, safety data, and then review it on the priority basis. Because any data, if you submit to any agency, see, in India, so many companies are working in drug development. So just pick that data, and that data is to be submitted to DCGI, Drug Controller General of India. So DCGI will review that data, panel of DCGI will review that data, and based on the review, that data will be actually considered, and the priority will be given, and the approvals will be given. Okay. So priority should be there for the emergency conditions like a pandemic. Okay, so in pandemics scenario, that review was for the vaccines only, priority was given to vaccine development only, and that's why we got the vaccine. Okay, so in drug discovery, yes, we do have fast track designations, accelerated approvals, breakthroughs, and priority reviews also. So now one more part of this future of drug discovery. So chemistry and biology, synthetic drugs, receptor theory, pharmacokinetics, all these things are there. So pathology conditions are there. So traditional medicines, conventional, if you look into the history, 1950 and 2010, there is a shift. There is a shift. Now we are into more into genetics, molecular biology, and system biology. Correct. So herbal medicines are also there, and we started with that in 1950s from herbal. Then we came into penicillins, and now we do have gene therapies, cell therapies also. So in summary, health is one of the important aspects of the human life. Health can be understood by various integrative approaches. Ill health can be categorized by various diagnostic methods. Point of care device testing devices are now integral part of human health management. API are support pillars of human health management. API discovery and development process is a systematic and planned activity. Advances in API discovery and development process are now expediting in its approval process, and biologically similar components, biosimilars, are gaining prime importance in recent era of API discovery and development. So thank you very much. So this is all from my side regarding human health, and it's what you can say is perspective. Basically, what I tried to give you is the glimpses of health, health definitions, then how the health is monitored by allopathy as well as Ayurveda, what are the concepts in Ayurveda, and beyond that, what are the diagnostics tests, point of care devices, and then during treatment, how the drug is developed, what are the basic necessities of the drug development, how much time and money it takes, how crucial this is, and how the AI and computer is advancing the drug development process. So this is from my side. Thank you very much. Dhanyawad. Any questions? Any questions? Any questions?
There is no any questions. Should I start the vote of thanks?
Hello, I'm roll number 46. Sir, I have one question.
Yes, madam.
सर जैसे कि हम कुछ फूड लेते हैं उस पर रहते हैं कि ग्रीन डॉट रहता है विच इज वेजिटेबल, तो आपने बताया जो ड्रग्स रहते हैं वो कुछ हार्मफुल रहते हैं बॉडी के लिए, तो हम बाई उसको जस्ट ऑब्जर्व करके आइडेंटिफाई कर सकते हैं क्या इसका डोज हमें ज्यादा लेना नहीं है या फिर ये हमें अवॉइड करने हैं?
नहीं
जो
नहीं,
लोग मेडिकल फील्ड से नहीं है क्या वो आइडेंटिफाई कर सकते हैं क्या ऐसा कुछ?
समझ गया। देखिए, एवरी ड्रग विच इज इन मार्केट, अप्रूव ड्रग, इज सेफ ओनली, मतलब सेफ एट सर्टन लेवल. Beyond certain level, it will not be safe. Okay, and that levels are already defined. For example, पैरासिटामोल आप लेते हैं, कैलपॉल, तो कैलपॉल का डोज फिक्स है, 500 mg ह्यूमन एडल्ट को देना है, दिन में 2 बार, एट द मैक्स 3 बार, क्योंकि उसका अपर डोज फिक्स है. तो ड्रग्स में आपके पास वो रेड लाइन, रेड डॉट या ग्रीन डॉट नहीं है, उसमें वो वेज नॉन वेज का आपको कंसेप्ट नहीं है. और वो जो डॉट है ना, डॉट, वो एक्चुअली रिप्रेजेंट करता है कि ये सोर्स कौन सा है. फूड में क्या होता है कि आपको वेजिटेरियन सोर्स से ही तो वो आपको ग्रीन डॉट आएगा, और नॉन वेजिटेरियन सोर्स होगा तो रेड डॉट आएगा. लेकिन मेडिसिन में ऐसा नहीं होता है मैडम. दैट इज फर्स्ट पार्ट. और दूसरा पार्ट है कि मेडिसिन में ये जो सेफ्टी लेवल्स है ये डिफाइन ऑलरेडी किए गए हैं. सो मोस्ट ऑफ द केसेस आपको जो डोज मिला है, इसीलिए यू शुड टॉक टू योर फार्मासिस्ट. डॉक्टर तो बता दी, लेकिन उसके साथ एक फार्मासिस्ट करके आता है, तो फार्मासिस्ट के इसके एडवाइस के साथ इफ यू टेक द मेडिसिन, देन इट विल बी सेफ फॉर यू. ओके.
Okay, sir. Thank you so much.
Okay. Anybody? चलो, thank you very much. धन्यवाद.
We will conclude with the
Thank
vote
you,
of
sir.
thanks.
Very informative session.
Hello.
Yes, sir.
Yes, sir. Good evening, one and all. I am truly honored to come online before all of you to offer a vote of thanks on behalf of UGC, HRDC, MMTC of Dr. Babasaheb Ambedkar Marathwada University. I would like to express my vote of thanks for today's afternoon session of the online 16th Faculty Induction Program. First and foremost, a huge thank you to our esteemed resource person, Dr. Sachin Bhusare sir, for gracing us with their presence and sharing such insightful presentation on Indian patent system, theory to practice, and continued another session on human health perspective. Sir, your overall presentation on Indian patent systems address truly inspired and enlightened us all. Dr. Sachin Bhusare sir has explained in detail about the Indian patent system, intellectual property rights, criteria of patentability, types of patents, type of patent application, requirement for filing application, patent filing procedure, copyright procedure, technical language for patent registration, etc. Important issue involved in patenting and another continued session in another session continued on health related issues, aspects of Ayurveda and Ayurvedic medicines, advancement of drug discovery, and many more important issues involved in health issues related to Vata, Pitta, Kapha, and naturopathy, homeopathy. Also, mortality rate and ratio is highlighted. Different disease related issues and health related issues and indicators, mental health diagnosis methods, genetics has been highlighted. Comparison of Ayurveda, allopathy, and homeopathy is discussed in detail. Comparison computers and AI in drugs discovery also discussed by Dr. Sachin Bhusare sir. As we end this session today, let us carry forward the insights shared here. Thank you for making this session full of knowledge of patent system truly memorable. My sincere appreciation also goes to our Director of HRDC MMTC, Assistant Director and Course Coordinator for their valuable contribution and for making this session so informative by inviting such experienced resource person on 16th Faculty Induction Program. I must also extend my heartfelt thanks to Dr. Rafe sir and all the person involved in the induction program and the entire staff of UGC, HRDC, MMTC for their tireless efforts in making this faculty induction seamless success. To all our wonderful participants, thank you for your enthusiastic engagement and for making this induction program truly special. Your presence and active involvement are what brings this gathering of knowledge. Once again, thank you for being here. We hope we found the session beneficial. We look forward to your continued support in our ongoing FIP. Thank you so much, sir. Thank you. Thank you so much.